clear that even that is arbitrary.
Not in every case.
Not in every case.
We're sorry, yes, we are taking some time. That's one. So your 8 was rejected.
Yes. And actually file the arbitration.
Human arbitration.
We file the arbitration.
It's an appealable order?
Yes, it's an appealable order.
Yes. What is the urgency now?
Because the urgency is the desire for this proceeding. Documents are marked. Because, yeah.
Objections removed?
Yes, the objections are removed, date is served.
Just take. Will you inform the date of the date?
I will inform the date with
When is the date of hearing for the court?
Because it is on the day of review. Therein lies matter.
Day of report is when after June, in June?
Yes.
Is it on that day or?
Yes, it's on the day of review.
Just give it in. Going here only. Just take it. Unless you have somebody. Yes, tell us.
Respond number 1 has been
Is it a fresh matter?
court has given a rebuttal to file a
Is it a pending matter or
it's a pending matter.
then file an early hearing?
Whereas court has given permission to
Which court? Permission to
divide the matter because
file an application then. File an application, then divide, file an application, then mention it. You'll get that application. Yes. And we have reserved it for judgment.
Yes, sir.
Sure that. Who is now giving these judgments? Who is the other side?
It is already inside.
Where is the signature received? When did you serve him?
Friday itself.
Oh,
Let's
take this.
Pending writ appeal was disposed by an interim order that granted my services to continue the academic year on the basis that my services were terminated only on the grounds that there was no requirement, but there is a fresh intake to this school.
What is the matter you have filed?
take detail video.
Against which order?
Against order of the single judge dismissing my services. However, this court granted me an interim order and continued my services for the previous.
What is the status today?
Because the previous academic year till which this court granted me to continue is coming to an end. New academic year is
When is it coming to an end?
So it has already come to an admission going on in fresh academic year.
For the fresh academic year, all objections removed.
Please, all
All are. And then the academic session starts.
May or June.
Must be something some other month. What is the stay application you have prayed?
I haven't filed any fresh stay application.
What is the old one?
The old one is.
Is it a pending matter? Is it a pending matter?
Pending matter, 23 of it.
Then who want to file a application, fresh application, and get that mentioned? Then mention them. Yes. Other?
Mic use one.
Yes.
Sir, mic use one.
It is urgency. Respect is construction building.
Yes. Yes. What do you want? Is it a pending matter? What have you filed? You filed a writ appeal. Okay. Is it a fresh matter? Fresh appeal? Objections removed? What was the matter before the learner seen the judge?
Sir, one nimisha.
Just give that to me.
No, sir. It's a fresh matter.
Who is appearing for the other side?
We are in person only. They are appearing in person only in the writ petition.
Where before the single judge?
Yeah.
Now, is it pending before the single judge matter?
No, sir.
Decided.
No. The petition, writ petition is decided in favor of one.
I'm having a 2:30, we will give you a date.
It,
2:30,
sir, I have to come all the way from my native place, sir.
which place?
Doddaballapur Taluk.
We give you a date.
Okay, sir.
You can come in the morning.
Okay.
You can come in the morning.
Okay. Okay, sir.
ಹಾಗೆ ಬರೋಕ್ಕಾಗುತ್ತಲ್ಲ ಸರ್
But welcome.
28 28/4 28/4 ಸರ್
Sir, next week.
Not possible next week. The urgency, what is the urgency?
Yeah, he is persecuting me too much
You will hear it. Where is he persecuting you?
in my property. To,
He's troubling you on your property.
yes, sir.
You will have
24/4 sir 24
Submission, my lords. There is a rare appeal, my lords. The appeal was dismissed against me, my lords. Now the amount has been deposited before the RERA authority. The respondent is trying to withdraw the amount, my lords. It's a fresh matter, my lords. Yes, please, my lords, I have a complaint. That's all, my lords.
Your Honor. Fresh memo for the commercial appeal that I filed the appeal for challenging the interim order passed by the trial court in order 39 rule 1 that is rejected, and that on that they misuse the property, that theater situated before in the Chittadurga Venkateswara theater, they illegally, and the name of the appellant, they run the theater from last 1 year. We filed they filed the caveat, we serve the copy, and we already proceed further. So for next week or 10/11 any date. That commercial suit has been filed by the plaintiff.
It's 24/4
Much okay.
Kindly switch. Pending before the CAT, Your Honor. CAT is dismissed the transfer order in railway department. We employee of the co-employee raised the complaint in transfer the, no, yes, Indian petitioner employee,
Right, but that has been dismissed.
dismissed, CAT dismissed it.
For
Per petitioner,
employee,
employee.
one that will be listed,
Transfer stay, Your Honor.
objections removed.
Objection, no objection,
There are no objections.
no objection.
You have already filed it.
Yeah. ಮಾಡಿದ್ದೀನಿ.
For adjournments, page number 9, 25, 26.
25, my lord. We are the appellant.
I am for the respondent, my lord. I have no objection.
25.
The request of counsel for the
14-7. Page number 10. 27 to 29.
Yes, 27, my lord, I represent appellant. My friend respondent is, my lord, I am the appellant in 27, my lord. My friend is also, my lord, seeks an objection. Adjournment, please, my lord. My lord, sir, appellant, my lord, Mr. A. Sampath, my lord, I am representing appellant's counsel.
Respondent, my lord.
Appellants, please, my lord.
14-7.
Oblige.
Much obliged.
Page number 11. 30
Serial
to
number.
34.
Serial number 29, my lords. I appear for the respondent in this, my lord. These are two commercial appeals against two applications, Order 7, Rule 10 and Order 7, Rule 11, filed by the defendant who's the appellant herein. It was dismissed, my lord. It's appeal against that. I'm the respondent in both the matters, my lord. I've informed the other side, my lords, but they indicated they wanted to go ahead. However, I have some inconvenience today, my lords. We informed them, my lords.
Page number 11. Serial number 1.
My lord, serial number 34, my lord. Appearing on behalf of the appellant, sprays time may be taken up after the vacation, my lord. We have informed the other side, my lord.
Inform the other side
Yes, my lord, we have informed the other side.
at the request of counsel for the appellant for adjournment, stating that she has informed the other side. Adjourn to. Leave it in.
14-7.
Serial number 44, my lord. Serial number 44, my lord. Finally, I mean, but the counsel on record for the railways, Mr. Satish Kumar, is no more, and the matter is entrusted to Shiv Kumar, my lord. Advocate Shiv Kumar.
But you're saying
44, my lord.
44. Who is for the?
Well, now the matter is entrusted to Shiv Kumar, advocate, my lord. Earlier, Mr. Satish Kumar was appearing.
He has filed the wakalat.
Filed the wakal. I have to serve him the paper books, my lord, and I also have some inconvenience.
We have been informed that.
Yes, my lord.
Mr.
Yes, I have informed.
We have informed that Satish Kumar and
No, I have informed Shiv Kumar. Shiv Kumar.
who has expired.
Satish Kumar.
Satish Kumar and the counsel appearing for respondents 1 to 3 has expired, and Mr. Shiv Kumar has filed his wakalat. He also states that the paper book need to be furnished to Mr. Shiv Kumar. If that be so, the same be furnished within 1 week. Re-notify on the name of Satish Kumar and be deleted from the memo part, from the cause list.
14-7. Serial number 1. Srimati Maitri Krishnan.
I appear for the appellant, my lord. I'm sorry.
Yes, ma'am.
My lord, I'm sorry, my lord. It appears that there's one office objection. If I may be
Just
permitted,
say
I'll clear it during the course of the day.
What is the urgency?
This is a appeal, my lord, against the order of the district court under section 34, which was against the order of the deputy commissioner under the NHAI. The deputy commissioner order, my lord, is at
The award set aside.
Yes, my lord, the award is set aside. The order of the deputy commissioner was on one single point, my lord. The NHI that go, if my lord may just see page 57 for a moment.
which is the order of the Deputy Commissioner.
Tell us.
My lord, on the appellant's land was notified and the compensation was paid at rupees 39 per square meter, my lord. On the other side of the
How much?
rupees 39 per square meter.
Okay.
On the other side of the highway, that is right across, that land was also acquired for the same purpose, and the compensation of rupees 428 per square meter was paid.
How much was your land from the highway distance?
It was abutting the highway, my lord.
What the other one also?
Was abutting the highway. It's the other
We
villages.
see it, but what is the objection?
So therefore, my lord, the Deputy Commissioner enhances the compensation.
You remove it, then only we can.
Very well,
show.
my lord. I will.
Let objection be removed during the course of the day. List on. Just give it 28.
28-4.
Grateful.
Serial number 2, Shri Prasanna Kumar.
I appeal for the appellant. My lords, we have filed a memo for retirement and we have communicated the same to the department, my lords. Since the case has been transferred from Bangalore branch to Hyderabad branch, they have, we seek a short accommodation for
The request of counsel for the appellant. Adjourn to. Just give it in June.
14-7.
Much obliged.
Serial number 3, Shri Nagendra Naik.
Hearing for the appellant, my lords. Sincerest of the apologies, my lords. Had to comply the office objections. It's ready today. I'll comply during the course of the day, my lords.
Objections be cleared within 1 week.
A short accommodation, my lord.
Just list on.
Immediately after vacation, my lord. Request. Immediately after vacation, my lord.
Yes.
9-6.
Next.
Serial number 4.
Translation copies of the Kannada documents be filed within 6 weeks.
Offering for respondent 1.
Translation of Kannada documents be filed within 6 weeks.
4-7. Serial number 5.
Same order.
Offering respondent 1 and 3, my lord.
4-7. Serial number 6. Government advocate.
R1 steps have been taken, my lord, on 3rd April.
I'm for the appellant, my lords. On 6/6/2024, the court ordered for connection of 2 other matters, my lords, which are arising out of the same order.
6/6/6.
This was the last one.
6 is appeal by government.
See, which are those connected matters? You should file an application. Get those matters listed. When we adjourn this, you get it matter listed, move a memo or an application. Because the last order doesn't say so. Possibly we may have said that you file a move a memo.
Lords, I'll pass on this daily orders.
What?
It is mentioned.
What is that?
We made a submission with previous date of hearing. It is mentioned that.
Show us.
Yeah, matter.
On which date? You say previous date.
Which matter you have made submission?
106 commercial.
Which date?
Lords, dated 6/6.
Oh, that's in other appeals.
Please, my lord.
Lords, it is arising out of the same order. Maybe connected before hearing. That is all.
This today 106 is listed. Today this is listed. Stand
Where is 106 here?
Lords, 106 is the one listed today.
Lord, 106 is preferred by government. State.
And when is the date in these matters? In those matters?
Date has not been given.
So this appeal will be listed along with those. That's right. Just say that our attention has been drawn to order dated 6/6/2024 in Comp 140 of 2023, wherein the court has directed to list this appeal, that is Comp 106, along with the appeal, along with the, how many appeals were listed?
Well, there are two more appeals which are to be connected with the present listed appeal. One is 140 and the other is 176.
Along with the appeal 140 of 2023. Acha, along with 172 2023 and 140 of 2023. Acha, okay. Along with this, we find that has drawn, just say this, has drawn our attention to state that along with this appeal, two other appeals, 172/23 and 140/23, are to be listed. The registry to check and registry to act in accordance with the order passed on 6/6/24 in Comp 140 of 2023 on the next date of hearing, adjourned to 172 and 140, no, 23. Registry to act. Yeah, give a date.
14/7. Serial number 7. KS Ganesh.
What have you filed? You have deposited it?
Yes, ma'am.
Oh, just show. This is in term 50% of the decretal amount. Where is the memo? Learner counsel for the appellant has drawn our attention to memo dated 31/1/25 to state that the, is it there? We can check on this thing, man, noting. He has deposited it. Man, just see the last noting, man. Registry is noting. Yeah. See, we don't have any noting also that you have deposited this amount. No, how much you have deposited? 50%. How much that comes to? Just say this.
Not 6 lakhs.
Just say this, learner counsel for the appellant states that he has filed a memo on 31/1/25 to show that the amount as directed to be deposited on What is the date of the order, please? 5/1/2025. 24. 5/1/24. The memo is not on record. The registry to place the same on record. on the next date of hearing. TCR. TCR has been requisitioned. Counsel for the parties to file their submissions along with the judgments before the date of hearing. Written submissions within 6 weeks.
20th June. Serial number 8, Gopal Swami.
I appear for the respondent now. I have filed my power already.
You now appear?
Yes, my lords.
Who has filed the memo?
One Mr. Yashwant Sajjana.
Mr. Yashwant Sajjana has filed a memo for retirement as so-and-so. What is your good name?
Sharath S. Gowda, my lords. My name is already reflected in the copy.
As Mr. Sharath S. Gowda has filed his wakalat after taking NOC, the name of Mr. Yashwant Sajjana Gowda be deleted from the cause list. Okay. List on. Just give a date.
20th June.
Next.
Serial number 9, Shri Vinod Prasad.
Louder. Louder. Mic, use the mic. File an application. File an application. Application. Just show us. How much we said? How much is the entire amount? How much is the entire amount? So then tell us, is respondents appearing? Have you served them? No. What is the date of execution? See, you should serve them first. You should serve the respondents. You have not served. So why don't you serve them first? You should have served them first so that they could have appeared. Then possibly we could have put it to them. The respondent number 1, the respondents are still unserved. There are more than one respondent. Only sole respondent. Acha, respondent is still unserved. Let fresh notice be issued for service on the respondent. You do it fast. Just give it first. You can do it. You want to serve him in the execution. Liberty is also granted to serve the respondent before the executing court. You serve him before the executing court. Just tell him.
Sir, executing court advocate serve ಮಾಡ್ತಾರೆ.
Okay.
Four six.
We are not saying anything. You should serve him first. See, let's be very clear. You don't deposit the amount. You want a stay order. We will look into it, but you should serve him first. If you had deposited the amount, possibly we would have said so. You have not deposited the amount. That's right. Serve him first. Serve him. When is the date in execution? When will you do that? Then it will go beyond that. In the first week of June, we are having it. Next.
Serial number 10. No Bharadwaj.
Yes.
Serial number.
Pardon?
Would your lordship please turn the order sheet dated 25/11? There are 3 items of office objections. One is memo dated 5/10/2023. We have not pursued it. This is one indication. Second thing is the next, we have death of some person. We have got to take action. That all these things have been done. Now, first I request my lord's kind attention to order sheet dated 25/11/2024. That memo dated 5/10/2023 came up for consideration, and the Honorable Court was not pleased with the narration made therein. Therefore, by imposing cost of risk 5,000, that memo is disposed of. Liberty is given to file a fresh memo. The reason is this.
Now, where is the next order after 5/11?
Yes, Milord. No. There's one explanation, if your lordship permits, I'll be there. Mr. Hari Krishna Holla was the advocate for the appellant. He passed away, leaving certain vacuum in his office. The reason for the youngsters could not comprehend the.
Right, Mr. Shankar, but this order is a preemptory order of 25/11. Finally, 2 weeks time.
Yeah, that is complaint. That is complaint.
When did
And
you
the
do
complaint on I've got the office. It's in the record.
When did you do it? Within 2 weeks or beyond 2 weeks?
9th December 2024. I think it is, we cut it fine, very fine.
Oh, 9 December you did it?
Yes. The acknowledgement is there. Memo is also there.
Is the registrar's report there?
And next is, we have filed. Shall I show it to the Honorable Court? Ninth December 2024, memo is submitted.
What was the objection number 1?
The party is not, why he was not made a party, why the dead man is not made a party to the appeal. So we pointed out that he died and in his place the LRs have been brought record. They are already on record. This was not comprehended properly by the office, and there was nobody to explain.
Who has died?
Please, Mila. First petitioner in the writ petition, first petitioner, Sadashiva, he passed away. His LRs are already on record. Gangamma, his wife and children. Then costly. The appeal is filed by Gangamma without Sadashiva. That is the office objection. By LRs. By LRs. Please give a little margin for the fact situation that Hari Krishna Holla passed away and the youngsters did not know. Yes, Pila.
Are you saying all this 1 to 6 all are LRs?
Yeah, please. That's please, Pila. Go on, my lord is. Yes. Then Miller Gangama also passed away.
That is during the pendency.
The misfortune is compounded. Her LRs are already on record. Yeah, my lord, your lordships have made it easy for me. 2 to 6 are the LRs of both the husband and wife combination. The delay is there for, presentation of the appeal. Death of the appellant is, that is submitted here, my lord. 27/12/2022. Gangama Sattidu.
Just say this, the history. The office of one with regard to the petition number 1 is the petition has not been made a party in the litigation.
Yes.
We have been informed by Mr. Shankar and the senior counsel for the appellants.
Sadash.
When did he die?
27th December 2022.
Was it during the pendency of the
Writ petition, he was alive.
It was during the pendency of the
When he was presented, he was alive. Before its termination, he died. Writ petition disposed of subsequently.
Why was it not
I can't tell lies. I can't invent an excuse even. Kindly pardon them.
during the pendency of the
Writ petition, which was not brought to the notice of the Honorable Court.
when the same was not brought to the notice of the court nor any application bringing a last
Yes. Right.
Was he the sole petitioner or the others were also there?
Others were also.
Yes.
Others were also.
He states that even the heirs of the Sadasivaya were party before the inter-alia.
Then Gangama died on 11/12. 1 year later,
He has drawn our attention to now this memo reporting death of whose appellant number 1, Gangama.
second memo is in respect of Gangama.
The memo is in respect of Gangama.
Two memos were there.
Yes.
Reporting death.
The 23/1 memo, Gangama. The 9/12 memo is that Sadashivaya.
9/12 memo is Sadasivaya.
Sadashivaya.
He has drawn our attention to that.
Yes, Bill, that is the memo that is dismissed with 5,000 rupees cost. That memo is rejected. She did not know how to present the fact situation, and the haphazard memo was filed. It was not accepted by the court. Memo was rejected.
On 25/11/24, this court had passed the following order. Mr. Shankar and the senior counsel for the appellant states that all the objections have been cleared according to you.
That's the order.
All the objections have been cleared
According to advocate on record.
on instruction. Mr. Shankar on instruction that all the objections have been cleared. The registry shall verify and in its report on the next day of.
In the meanwhile, a continuation of delay could notice go. I've understood the procedure. And please, it will be there next week, if it's possible. The reason is this: the learned single judge would say, we have not produced proof of having received the amount. Who should receive the amount? my lord, we have already lost 2% elderly persons in the, sorry. It's only for verification. My lord is asking the office to verify.
28-4.
Please, madam. I am grateful to the honorable court.
Serial number 11.
It's for the petitioner. Seek a week's time, my lords. My lords, office objections are raised, my lord.
10-7. Serial number 12. Serial number 12.
Appellant in this matter. My lords, series of connected matters, my lords. Parties are exploring settlement. May we request this matter be had on the 15th, my lords? This month, we will report
In fact, my
settlement.
lords, the terms are already agreed upon. We are in the process of drawing up agreement. So it's very likely that we will be in a position to submit.
Parties will be present and will report, my lords. One of our clients is, may I only make a request, my lords? One of the parties is traveling in April. So the entire process may get delayed. Of course, no doubt. It's only a request from both our side.
My lords, 21st, 22nd, my lords. Both serial number 12 and 13.
24th.
Very well.
24th. 24-4.
Interim orders may be extended. Please.
25-4, sir.
Obliged.
The interim orders might be extended. Please, great.
Very well.
Serial number 14. 14.
I'll take steps. Please, I will issue. I'll take steps. And my lords, liberty may be permitted to serve the copy who is in the writ petition. Please, please, please.
11-7.
Said heard this matter last occasion, your lordship said heard this matter.
In item 14.
Please, my lord.
The name was not shown, my lords. That's it.
Lord, I appear for the NMC, MCI, but I have not been served a copy yet.
In which matter?
14.
Sir, 14, sir. Sir, are you in 14,
Are you
sir?
appearing in 14?
Yes, serial number 14, my lord.
Which respondent?
For the medical council, my lord, now NMC.
Okay. Just say that though
Copy may be served, my
respondent I recollect
A learned friend may do that.
though respondent 2 and 3 are still unserved. So what is a good name? So and so appears. Yeah, Mr. Iyer appears for the respondent number 2 and accept notice. Let a copy of the appeal paper book be given to Mr. Iyer within a week's time. Let fresh notice be issued for service on respondent number 3. Returnable on.
Sorry.
It may be corrected to Kheti, my lord. That's the next. Screen, my lord.
NKT, my lords. His name is NKT.
Okay, whatever is the name.
Please.
Please, my lord.
Say it.
Please.
12-6. Serial number 15.
15 for appellants, my lord. The
Appear for respondent.
lords, 15, my lords, for the appellant, they file an application for release of the amount, my lord. I'm just misplaced the IA copy which they have given it. First form objections, my lord, we have.
IA 1 of 25 was duly served.
IA 1 of 25 am in custody, my lords. The IA 1 of 24.
That is for vacating stay order.
So we want to file objections, my lords, raised for term.
So IA 24 is for the release of the amount.
Release of the
For
amount.
release
My lords.
of amount.
There is some rectification for vacating the interim order, 1 of 25. There is some objection.
No, objection is saying that it is not served, but it is duly served. I have copies.
Vacating, my lord, is served. That may be overruled, my lord. And,
What is the issue notice on IA 1 of 24? Okay.
That's also maybe.
Okay. Just say this. Learner counsel for the appellant seeks and is allowed how much time to file reply?
2 weeks, my lord.
2 weeks to file reply to 1 of 24. Full stop. Insofar as the objection on IA 1 of 25 is concerned, the learner counsel for the appellant concedes that he has received a copy of the
Yes.
application. Full stop. 1 of 24 has become infructuous. No, no. Say that as the counsel for the appellant appears in 1 of 24, notice on the said application and had accepted notice on 10/2/25, 25. The issuance of notice on 1 of 24 shall not survive. Full stop. Accordingly, in view of the above 1 of 25. No, full stop. Just say that re-notify on for considering 1 of 20 for consideration of IA 1 of 24.
And IA 25 also.
IA 1 of 25 as well. 1 of
This-
24, 1 of 25. The registry shall give its report on IA on the prayer made in 1 of 24. We'll call for the report on the deposit made.
We are deposited. Please, it could be recalled for. We are already deposited.
Have depositor, they'll give the interest
Two lakhs.
component also. No?
Please.
Next.
Objections is also filed.
Objection no required. We have noted he has received
Obliged.
that application.
17:6.
Obliged.
Serial number 16. Jayakirti.
Matter for the appellant. This matter was adjourned with a understanding that matter itself can be heard. The short point is involved.
We'll just pass over.
Seventeen.
Lord, I'm appearing for the appellant in this matter, my lord. There are two IAs before your lordships. One is for condonation of delay and one is for stay. Now, condonation of delay, my lord, what has happened is the registered appellant, his office, registered office is in Hyderabad and their communication is from Mumbai, my lord. So the communication had taken time to reach us and that's why there is a condonation. There is no intentional delay. The
Who is
delay may be
appearing for
condoned,
the
my lord.
others?
Served and unrepresented.
Also. Just see your application.
Yes, my lord.
Then how many respondents are there? Just show us the application for condonation.
My lord, IA number 1, my lord.
Which paragraph?
My lord, if you look at paragraph,
How much is the delay?
we had calculated to 70 days, my lord, but the office had calculated 101.
A huge delay.
It is, my
We are
lord.
in commercial appeal.
Please, my lord, but the communication was the problem because the head office, the registered office is in Hyderabad. It had to go to Mumbai and then come to us. And we were just,
That's none of our concern. And this 101 is over and above 60 days.
please, my lord.
So
My lord, we had come on record only for the appeal. We were not even the counsels in the trial court. So by the time it came to us, there was a delay.
We will look into it on the next date of hearing.
Please, my lord.
Because the only thing is the other side, despite service, they are not appearing. Let's see that. Okay? Despite service, though the learned counsel for the appellant presses the application seeking condonation of delay, as there is no appearance for the respondents despite service, we deem it appropriate to adjourn the appeal to. We will consider it on the next.
Please, my lord.
23-6.
Much obliged.
Serial number 18.
Yeah, good morning. This is Subramanian here. I'm appearing for serial number 18 as an appellant. My lord, I would like to request for a change of my current advocate. I would like to request to discharge my current advocate, Advocate Bharti Patil, and allow me to appoint a new advocate presence. Unfortunately, I have not been able to come in person because my father is not well, so hence I had to appear through VC.
What is your name?
Subramanian Iyer.
Have you engaged a new counsel?
No, I'm yet to engage a new counsel.
Now, who was the counsel you want to discharge?
There's Advocate Bharti Patil.
Okay. Just say that Mr. Subramaniam Iyer, the appellant, appears in person and states that he has discharged Mr. Bharti Patil Tamanna Gowda as his counsel. He also states that he intends to appoint a new counsel and request that the appeal be adjourned. At his request, we notify on.
Lords, I am also not served the copy of IA number 1 of 25 for direction.
Let a copy of IA 1 of 25 be served on the counsel for the respondent. Respondent number 1.
Yes.
Who are the other respondents?
Tribunal is the second respondent.
I don't think we require. This shows the notice to respondent number 2 is dispensed with. Is there any order?
He's appearing now.
No, respondent number 2 dispensed with. Dispense with. Okay. Just say this same model, ma'am. Appellant appears in person. Mr. Patil is discharged.
15-7. Sir, 15-7 date.
Okay, thank you very much.
Grateful, Madam.
19.
Here for the respondent.
19.
Appellant in this case, my lord. Kindly have it on next week, my lord. Senior Lexin Portal 1, my lord. Senior Lexin Portal 1. Kindly have it on next week, my lord.
Yes, Mr. Gunja.
Please, my lord. It was a judgment against admission, my lord. He admitted he will pay the amount. At least I may permit to withdraw the amount and deposit, my lord. To that extent, I may be given the relief. I made an application, my lords.
Why this 8266 delay? Huge day. How many years?
Appellant is dead, my lord.
2008 order you are challenging.
Pardon, my lord?
He is challenging 2008 order.
Yes, my lord.
What is the explanation given?
Please, my lord. Your lordship may kindly turn to page 36, my lord. Page 6 of the judgment, my lord. Another vital document, Exhibit P18, which is a reply notice issued by the defendants. Next, I'm sorry, my lords. Next is my case, it seems. Next is my case. I'm sorry, my lords.
Yours is next. Who is the?
Next.
Just say at the request of counsel for the appellant. Give it up.
8-7.
Much obliged.
Serial number 20.
Here for the appellant.
Now counsel. Yes.
May I take my lords to page number 41, 81, 82 and 83.
At page 41, my lord.
He has filed an application for withdrawal of
Yes,
the
my
amount.
lord. That I have no objection, but the whole matter could be disposed of because, as I said, just these 4 pages. Page 41, my lord, the suit claim is for 12 lakhs 18,567 rupees with interest. Page 81, my lord.
You said 41, no?
Yes, ma'am. That is the decree. The suit claim is
It's for 12 lakhs.
12 lakhs
Or-
18,567. Now, my lord, may turn to page 81, please, which is the order sheet dated 1/12/23. The third paragraph. The plaintiff counsel filed memo along with one statement showing total amount payable by defendant as of 30/11/2023, including interest as 4,85,688. The total amount payable as on that date is 4,85,688.
Was interest is 485 or the principal was 485?
The total amount including
See
interest
plaintiff
payable,
count memo along with one statement showing total amount paying,
payable
including
by defendant.
Okay, 485.
Yes.
This was in 23.
Yes. Now kindly see the order at page 82. The suit filed by the plaintiff for recovery of sum of 12 lakhs 18,567 from defendant jointly and severally, along with the rate of interest at 24% per annum, is decreed with cost. Prima facie, there is an error.
Yes, Mr. Gunjal, what do you say?
Please, my lord, at page 36, you launch me kindly. Page 36, my lord. The learned judge has given the reason why cross-examination is not permitted instead of taking adjournments, my lord. In exhibit P18, which is a reply notice given defendants to the counsel, in this reply, it is mentioned they are ready to make the payment of outstanding amount with some adjustment in tandem with the defendant's books of accounts. They admit the liability.
That's right. No, but tell us one thing. This 41, 81 is your stand.
No, they are the plaintiffs.
Let's read it once again.
Yes.
As a plaintiff counsel.
Plaintiff counsel filed.
The submission is, you have said you filed a memo stating that the amount payable is 485,688, including interest at page 81. Okay.
Please, madam.
This is what you have said. This is on 30/11/23. The suit was decreed on
4/12/23.
This was
on 4/12/23. The suit was decreed with 12 lakhs liability.
No, I'll make this clear, my lord. During the pendency of the suit, they paid some amount. I have reflected that, my lords, and now they are due to me exactly, my lords. I worked out the concession I have already given that has been given, my lords.
No, but you say this is the total amount payable, 4,85,000.
Then I will file the memo of calculation by tomorrow, your lordship. I'll show that amount, what is in this is not correct.
What is the submission we are saying so that you can look into it? He says on 30/11 the liability was 485.
Yes.
Just a month thereafter,
Please,
the
my lord.
liability has been fastened for 12 lakhs odd. We say how that is possible.
Yeah, I read it. Like, the plaintiff and the payments made by defendant given the deduction to the same, and the claim is deduced as per statement of calculation now produced by the plaintiff. My lord, this amount was considered, my lord. I'll give my memo of calculations by tomorrow. That's the only minor this thing, my lord. I will clarify that. My client is here. I'll talk to him by tomorrow. I'll clarify.
But then why did you file this memo? So the liability cannot be more than 485.
Please, my lord, that was the payment which he made during pendency of the suit. For that, we also sought a refund of the amount of the additional court fee paid. I'll make myself clear, madam, on that issue tomorrow.
We'll see it. Learner counsel for the plaintiff has drawn our attention to page 81 of the paper book to content, as per the respondent himself, the total liability The total liability.
Because the
That was represented by the
4 lakhs.
respondent herein was
Illa, sir.
only for an amount of
total
4,85,688
688.
688
shooting,
as on 30/11/23. Whereas the trial court has decreed the suit for an amount of
12 lakhs.
12 lakhs.
an amount of 1,2,1,8,567 on
E case na loud
On
412.
4/12/23.
I'll file with the memo. I've got the calculations, I'll file it.
You will file that. You will look into your memo also, which you filed before the trial court.
No, that observation may kindly be, I will explain that tomorrow along with the.
That's the reason we are saying, look into that also. Have you said that subject to adjustment, this is what has been, need to be adjusted for paying the complete amount?
I'll produce that memo also.
Okay.
I'll produce that memo also. What he's telling, if I may say, look in the first place, correct my lord. It is not so. That's the reason I'm making a submission. Tomorrow itself, I'll clarify that.
How much was the suit filed for?
12 lakhs 18,567.
18?
12 lakhs 12,185.
It was 12 lakhs. If that be so, Mr. Gunjal shall look into the, shall file a calculation, shall file the amount as due and payable to the respondent.
This is how he has
To
cleared
the respondent by way of
parts.
his
when the
statement
Suit was filed. the
on
due
the
was
next date
16
of
lakh.
hearing.
4 lakhs was the interest, only
By
interest.
also taking into consideration
May I pass on these calculations, my lord? It's not supported by any explanation. That's a,
the
not
memo
by the
filed
memo.
on 30/11/23 before the trial court. You give it to him also?
I'll pass on this to him. I'll explain to him here itself. Your Honor, kindly see, on 16/6/2 on 17, the total outstanding was 16,24,000.
It's all right. You will give it to him also. Let
In
him
that
also.
he has paid 4 lakhs. So 12 lakhs we have claimed. The suit has been properly decreed, my lord.
Where is that amount which you have shown in
Was
the?
16,24,487. Your lordship is right. This
No, we
date
have
of the
seen
suit.
that. Where
So
is
we
the?
gave deduction for that 4 lakhs. The suit was filed for 12 lakhs.
Okay.
That's the reason the suit has been appropriately decreed, my lord.
But the way the trial court has observed it, impression one gets is that's the total liability.
No, that's the reason I said, my lord, I'll
Where
explain
is your
that.
memo? Where is your memo?
I'm looking for it, my amount of start this thing, my lord.
You have that memo?
That's right.
My lord.
See, the memo should be filed now. What did they express?
We were not present.
I was present, but they didn't do don't agree, they didn't give.
Counsel was present on that day. He says a copy was not furnished.
Copy was not given. You filed your memo also, everything. Let the full stop.
Tomorrow it will be taken, I'll file it. I'll file with them. That's the reason I could not, without memo, I did not want to file it, my lord.
So suppose if it is 12 lakhs liability, where do you stay? Where do you stand?
I will have a problem.
I think possibly, that may be a, see, if it is 4 lakh, why will he file a suit for 12 lakhs?
When he filed the suit, it was 12 lakhs.
So what is the payment between the filing of the suit and this date?
My lord, 9 lakhs odd was paid is what I am told.
When?
During the pendency of the suit.
9 lakhs was paid. Amount due is 9. Interest amount is this. Total payable is 16.
On the day of filing the suit, sir.
On the day of the suit, he had to pay 16,24,287.
That's right. What he says is, the counsel says 9 lakh odd was paid during the pendency of the suit.
Yeah, on the left-hand side, I mentioned the dates, sir.
We are given all the dates when he has paid. We are not suppressing a single, this thing. I'll share with him, my lords. I'll share this with him. Let him come back.
Amount paid is 9,25,000. That's right?
Yes, sir. Please, please, please.
Oh. See, we'll tell you. You have that statement? See, come to the bottom, that final tabulation as per court order decree.
Yes.
Decree amount 12 lakhs, amount paid 9,25,000.
Yes.
Outstanding amount on 15/1 is 2,93,567. Interest on the decree is 4 lakhs. Interest on the principal on the date of the filing of the suit, we don't know. He said 24 per us. Awarded suit, these are all cumulatively. Now it comes to how much? 33,73,81. So he acknowledges that 9 lakh, he has adjusted 9,25,000. Now he is going by the decree and computed this 33 lakhs.
But even so, 9,25,000 is paid after the filing of the suit.
That's right. So what you say is it after the filing of the suit, before the decree?
Yes.
Okay. So 12 lakhs minus 925 need to be adjusted
Yes.
on the balance. And interestingly, if you see, outstanding amount is 15/1, 2,93,567.
Yes.
Then he has calculated interest
Which
on decree amount may not be sustainable.
Which is 4 lakhs odd.
That's right. It has to be on 4 lakhs odd. Mr. Gunjan, you have this calculation?
Pardon, my lord?
You have this calculation?
Yes, sir. Yeah.
You will understand this.
Yeah, I got it.
Sir, I have it.
You have it now, see this.
Yes, my lord.
12 lakhs is the decretal amount.
Yes, sir.
This 9,25,000 has been paid during the pendency of the suit.
Yes, sir.
That's right?
Yeah.
So decretal could not have been 12 lakhs.
No, that is the reason, my lord. I will rework this and I will explain to the court.
Do that. Do that.
Tomorrow or next week, my lord.
We'll have it next week. There on this.
25, sir. Serial number 21. Serial number 21.
Just give this to him. Just take this.
For the
Yes.
appellant, my lords.
21.
Matter may be passed over, my lords.
Last
There is
occasion,
on
I
the
have
slide.
filed a written synopsis also 26 as per the directions of your lordship. 26(3). Along with judgments.
Just pass over.
Great for this.
22. Serial number 22.
Should I appear for the appeal? In this matter, your lordship directed me, Lord, they have filed IA for withdrawal of money deposited by us. This honorable court directed that to file written synopsis by both of us to hear on main.
You filed your synopsis?
Yes, my
You
lord.
filed it?
Yes,
my lord.
Mr. Ji, you filed it?
Yeah. We are filing the synopsis right now. Written arguments also.
Yeah, we will have it somewhere. You file it.
Yes, not short.
Change it.
Yes. In 30 seconds, I can explain the issue, my lord. There are two survey numbers, survey number 15 and 16, which have been acquired in the year 2007 for expansion of national highway. I am the owner of survey number 16. So far as survey, both awards were passed by the original authority assistant commissioner. It went to arbitration before DC under the procedure under section 3G. Before the DC, he enhanced it to 6,000 and odd per square feet for both the lands. There was one AS number 2 and one AS number 8. The DC enhanced it to 6,000. It went to arbitration suit, National Highway Appeal. AS number 2 was upheld. The DC's award was upheld. The appeal was dismissed. National Highway Authority, that is my neighboring land. National Highway Authority admitted this position, admitted this and paid the compensation. So far as AS number 8, because it had come before a different court, he allowed the appeal.
Oh, their appeal.
Their appeal. It's just neighboring land.
And that also neighboring land.
Neighboring land. Then we came before this honorable court. This honorable court remanded it to the AS court and said that take a relook, keeping all these into consideration. Now the AS court has upheld it and said that it should be similar because lands are similar.
Now,
Adjacent.
are these acquisition under the same notification?
Same notification.
Same notification.
Very same notification. That is undisputed. So therefore, my lord, now highway, after having accepted this same 6,000 for the adjacent land out of the same notification.
File your submission.
We have
Vishal.
filed submission, and my lord, it is not as simple as senior counsel is trying to put it. It's totally different aspect, and my lord, I will just make all the submission. It won't happen in 30 seconds, my lord. It will take time for me.
Just say that you have filed it in the registry.
And right now I'm filing, but
Just
today
say
I'll
that.
file it.
Yeah.
I filed at the registry in January itself.
No, when did you file it, Ms. Shah?
January
Are there submissions on it? Just say that submissions,
22nd January.
submissions filed by the appellant are on record. Mr. Reddy and the senior counsel appearing for the respondent number. One states that the submission shall be filed during the course of the day. You have given to him, you have got the copy of this?
Where? Our copies. Yes.
The same shall be filed by
Yes,
giving a
we have got
copy.
it.
The same shall be filed by giving a copy of the same. Copy to the learned counsel for the appellant. List on, just have it after vacation.
But can it be before vacation, but one date?
So ready, it's very difficult. Code is actually heavy. Very
One,
difficult.
one chance will take.
No, we are only trying to accommodate where there are Parthar matters.
Yes.
We know. We'll have it in the first week of June, immediately.
First
3rd of June.
Where? Please,
3rd of June.
please.
Next.
Can it be in the second week of June? Second week of June. Second. Any date?
10/6.
10/6. Please.
23. Srimati Sumana Nagana.
Lordships had begun hearing this on the new pension scheme.
How long this would take, Mr.
Take at least a couple of hours.
Yeah. We'll have it post vacation also,
Please.
not now, Mr. Okay. Just say this, re-notify this appeal, these appeals on.
Sixth of June.
6th. Yes, please. Interim order may be continued.
Interim order, if any, to continue. Yes, Mr. Hola.
Please.
54.
Yes.
Lord, your lords may recollect, this is that matter where, my lord, the developer, owner and the developer entered into agreement. Building was constructed, sharing was done. Short question is, my lord, whether RERA Act will apply, because under the terms of the agreement itself, my lord, he is entitled, if there is a delay, of, my lord, 15 rupees per month, whatever the damages. Whether, my lord, RERA would apply is first question, my lord, which arises for your lordship's consideration. As I pointed out, the definition of RERA itself, my lord, indicates promoter, my lord, includes. I prepared a short note also, my lord, for my lord's consideration. First of all, my lord, the arbitrator came to the definite conclusion there is no delay. That has been affirmed in section 34. Secondly, my lord, whether RERA would apply, section 2K of the RERA, my lord, promoter means person who constructs or causes to be constructed. My lord, serial number 2, answer, my lord, serial number 2, 2ZK. Promoter means a person who constructs or causes to be constructed an independent building or buildings. Building consists of apartments or converts existing building or part thereof into apartment for the purpose of selling all or some of the parts to other persons. Para 6 of the joint development agreement, my lord, specifically states, appellant in order to discharge the loan, my lord, this is more important again. Agreement itself says, appellant, my lord, that's the my lord, owner, in order to discharge the loans that he had taken and for better returns has decided to develop the scheduled property into multi-story residential complex and has approved the developer offering the scheduled property for development. Therefore, appellant squarely falls within the definition of promoter in terms of section 2ZK. RERA, my lord, has issued a circular. My lord, this is also important. We have filed, my lord, the what documents, my lord, they are not produced, my lord, we have filed. RERA, my lord, can I, my lord, pass on? Nodi, Otherly, I don't know whether you got the file. ಒಂದು ಈ ತರದೊಂದು ಹಾಕಿದ್ದೀವಿ ಯಾವತ್ತು ಹಾಕಿದ್ರಿ 4th we have filed documents, my lord, which they had not filed, my lord, which are part of the we had filed ಅಷ್ಟೇ ಇದೆಯಲ್ರಿ what is it ನಾವು ಕೊಟ್ಟಿರೋದನ್ನ ಬರೀ very well ಕೊಟ್ಟನಲ್ಲ Lord, please come to page 103, my lord. This is, my lord, sorry, 103, my lord. RERA itself, my lord, RERA authority has issued, my lord, this circular dated 6/11/2019. Clause 1, my lord, whereas, please come to, my lord, the bottom. Sorry. Please come to, my lord, the next page. Page 104. Second unnumbered paragraph, my lord, for continuity. Whereas for the ease of filing online registration application for the benefit of the customers, it's necessary to distinguish or identify whether such promoter is landowner or is actually containing the building permission for carrying out the construction and is in fact carrying on construction. Therefore, it is directed that such individual promoter organizations who fall within the aforesaid definition of the term promoter on account of being landowners shall be specified as such at the time of online registration with the Karnataka Real Estate Regulatory Authority. So even as per, my lord, the circular issued, my lord, he is a promoter. The owner, my lord, is a promoter. ZK, my lord, 2ZK itself, my lord, indicates. Then, my lord, LOT, my lord, serial number 5 at page 2 of my note. Section 2D of RERA, sorry, 2D of RERA defines LOT to mean a person to whom apartment has been allotted or sold or otherwise transferred by the promoter. My lord, promoter is owner, my lord, also is a promoter, developer is a promoter. Then, my lord, section 18 of RERA specifies that if the promoter fails to complete or give possession of the apartment in accordance with the agreement for sale, LOT shall be entitled to damages. Since appellant is a promoter and not an LOT, he definitely is not entitled to damages in terms of section 18 of RERA. Repeated clause C of clause 4 of joint development agreement stipulates that the developer shall be liable to pay a sum of rupees 15 per square foot of saleable super built area falling to the share of owner if there is a delay beyond 12 months. Even assuming for the sake of argument that clause 18 of RERA possibly applies to the appellant, he is deemed to have contracted out of section 18 as is apparent from repeated clause C of clause 4 of the joint development agreement, page 15, wherein the appellant has specifically agreed that in case of delay on the part of the developer in completing and handing over the share of the appellant within 12 months and the extended period of 6 months, damages of 15 rupees per square foot is payable. Supreme Court in a number of cases has held one can always contract out of a statute. See Maxwell on interpretation. My lord, can I request your lord to look at, my lord, a compilation that I have given to my lords? The compilation of judgments I have given to my lords.
Yes.
Please come to, my lord, page 106. Maxwell in interpretation, 12th edition.
Yes.
No matter. Last, my lord, last paragraph. Everyone has a right to waive and agree to waive the advantage of law made solely for the benefit and protection of the individual in his private capacity, which may be dispensed with without infringing any public right or public policy. My lord, Latin phrase is there. So the person may agree to waive the benefit of Limitation Act. Then, my lord, judgment of the Supreme Court is next page, 109. Please come to, my lord, paragraph 2, 3, 6 and 7. My lord, 6 and 7 should be more than sufficient, my lord. I'll not trouble your lordships with. At, my lord, page 111, general principle is everyone has a right to waive and agree to waive the advantage of law or rule made solely for the benefit of and protection of the individual in his private capacity, which may be dispensed with without infringing any public right or public policy. Thus, the maxim has sanction of non-observance of the statutory provision, well, that in phrases indicated. See Maxwell on Interpretation of Statutes, 11th edition, page 375 and 376, which I just now read, my lord, that's the earlier edition. If there's any expression prohibiting against the contracting out of a statute in it, then no question can arise. That's why, my lord, I pointed out, my lords may recollect, the provisions of, my lord, the Payment of Wages Act, section 23. My lord, there's a specific bar. You cannot contract out to the statute. That's, my lord, I'll just read it out, my lord, aloud for my lord's consideration. Vidya, Payment of Wages Act is the
That is understood in the context of ultimately those are wages for
absolutely,
the
absolutely. No, public policy. Not only that, what I am submitting before your lordships is, therefore, my lord, if your lordship, please have a look at, my lord, the judgment of the Supreme Court in page 112.
Yes.
If there is any express prohibition, my lord, line number 1,
yes.
2, 3, yes. Express prohibition against contract out of a statute in it, then no question can arise of anyone entering into a contract which is so prohibited. But where there is no such prohibition, it will have to be seen whether the act is intended to have more extensive operation as a matter of public policy, etc., etc.
There is no prohibition.
Absolutely not, my lord. Then the next judgment is, my lord, running page 114. Paragraph 10, my lord, at running page 120. That was, my lord, under the Income Tax Act. In fact, my lord, my lords may recollect, under the Income Tax Act, my lord, Income Tax Act, my lord, has certain public element also. But even then, my lord, see what the Honorable Supreme Court has said. But the most important principle on the basis of which order of income tax officer should be upheld is that it is in pursuance of an agreement between the parties which has obtained the imprimatur of the court that this order has been made. Period of limitation is one intended for the benefit of the person whose property has been seized. It is open to him to waive it. We consider that to hold that the period of 90 days, which is mentioned in section 132(5) of the, is an immutable one, would cause more injury to the citizen than the revenue. It is therefore open to the aggrieved person, as happened in this case, to agree to a fresh disposal of the case by the income tax officer, thereby waive the period of limitation. Then the third judgment, my lord, of course, there are a number of them. My lord, selected, my lord, and kept 4. Please come to, my lord, page 124. In this, my lord, paragraph 15 at running page 131. My lord, surety, my lord, can waive his right. Para 15, page 131. This court is in respectful agreement with the decision of the Karnataka High Court in T. Raju Shetty versus Bank of Baroda, whereby the High Court held that in surety agreements, surety can waive his rights available to him under the provisions of under various provisions of Chapter 8 of the Act. That's a Contract Act. It is in line with the long-established precedents that anyone has a right to waive the advantages offered by law, provided they have been made for the sole benefit of an individual in his private capacity, does not infringe upon the public rights or public policies. This can be inferred from the reading of Aylesbury's Laws of England, Volume 8, 3rd edition, page 143, which reads as under. As a general rule, any person can enter into a binding contract to waive the benefits of the benefits conferred upon him by an act of the Parliament, as it is said, can contract himself out of the statute act, unless it can be shown such an agreement is in circumstances of the particular case contrary to public policy. This is not, my lord, in this case. Last judgment, my lord, is where again, my lord, their lordships have held waiver, my lord, is permissible. Page, my lord, 137. In this, my lord, paragraph 14, 9 and 14. 9, my lords, get that at running page 144. My lord. Next question for our consideration is, can a mandate requirement of a statute can be waived by a party concerned? In answering this question, we are aided by a catena of judgments of this court as well as the Privy Council. We will first refer to the judgment of the Privy Council, which has been consistently followed by the Supreme Court in a number of subsequent cases involving similar points. In Velayan Chettiar versus Government of Provinces of Madras, Privy Council held that even though Section 80 of CPC is mandatory, still non-issuance of such a notice would not render the suit bad in the eye of law because such a non-issuance of notice can be waived by the party concerned. In the said judgment, Privy Council held that the protection provided under Section 80 is a protection given to the person concerned, and if in a particular case that person does not require the protection, he can lawfully waive it.
That's the intent.
Absolutely, absolutely, absolutely.
There is
More than
something
that,
which would have inured in his benefit, but he still say,
that's
I will
right.
waive
That's
it.
right. Absolutely. In this case also, my lord, it is the individual, my lord, has to, my lord, seek, my lord, damages. Therefore, it is to his advantage or the benefit alone. Nobody, not the public, this thing. Therefore, my lord, this is one aspect, my lord, which I am placing before your lordships. Secondly, my lord, as I pointed out, the arbitrator himself, my lord, says there is no delay. My lord, this finding is, my lord, has become binding because it's Section 137, Section 37. Please look at, my lord, the award. My lords,
The same compilation?
my lord, no, that is, my lord, all the judgments. We had filed, my lord.
Just
Nilva.
shows.
See, huh. Right. My lord, can I request your lordships, my lord, to take the award itself, my lord? Appeal memo. ಎಲ್ಲಿದೆ ನೋಡ್ಬೇಕು ಬಂತ
Yes. Which page?
243, my lord. 243. Paragraph 74.
Yes.
Printed page 35, my lord.
That's part of the award?
Yes, my lord.
Okay. 243. Yes.
My lord, award starts at 209 at 243, then para 74. Other factors that leads to inference that there is no delay on the part of the developer are the following: auction of by IDBI, old house of the owner to be demolished, Unishare suit withdrawn in 2015, earlier arbitration before the same arbitrator ending in compromise leading to the sharing agreement being signed by the parties. In, my lord, on 3/7/2017, it must be, my lord, not 2107 but 2017. Writ petition by the claimant challenging the occupancy certificate. Huge rocks found during while digging work was undertaken and removed during May 2016. Demonetization factor. Writ petition in 2016 by the neighbors to the scheduled property. Writ appeal filed and dismissed on 23/2018. Modified plan approved on 11/1/2016. Respondent sending draft sharing agreement to the claimant on 4/7/2016 and claimant refusing to sign it. Respondent initiating arbitration proceedings by notice dated 17/12/2016 and the case ending in compromise. Period spent was from 4/7/2016 to 1/7/2017. Legal possession of scheduled property continued to remain with the owner as per clause 3 of Exhibit P1 and as per clause 10 of the agreement dated so and so. The possession was handed over on the said date for the purpose of construction. Therefore, my lord, all these reasons have been held to, my lord, justify the delay if there's any. That, my lord, has been affirmed by the Section 34.
Yes.
Then, my lord, please look at the second contention, because there are only three contentions that they raised, my lord, in my petition, my lord, in my note. Page 3. Arbitrator awarded interest of 1 crore 6 lakhs without assigning any reason. My lord, that's the argument that was canvassed. This is not at all true. Reasons ascribed by the arbitrator with regard to the interest payable in respect of the loan amount, which was paid by the respondent for and on behalf of the appellant, has been considered by the arbitrator, answered in favor of the respondent at para 72 and 73. That is, my lord, pages 297 and 298 of, my lord, we filed, my lord, a bigger compilation. That, my lord, is not before your lordships. It has not come, I believe. One idra agodilla, eradu kodbeku. Doesn't matter. My lord, in this, my lord, the award, my lord, your lords may take page 72, my lord, paragraph 72. My lords get that at 242, my lord.
Yes.
My lord, what I had put here, my lord, 297 is we had filed, my lord, a whole compilation of, my lord, missing documents. And, my lord, the award and all that, my lord, in one compilation itself.
Okay.
That, my lord, I'm sorry, that is why, my lord, if you let's look at my note itself in the beginning, reference to the page numbers in this reply arguments are document compilation filed by the respondent is what I said. Doesn't matter, my lord. Please come to, my lord, the award, para 72, my lord.
Yes.
At 202 or in, my lord, printed page 34. Respondent has produced exhibit R3, which is a statement showing payment made by the developer to IDBI. My lord, owner had obtained loan from IDBI. I had to clear it. Respondent has produced exhibit R3, which is a state, respondent is me, my lord, the developer, which is a statement showing the payment made by the developer to IDBI. It is at page 53 of volume 1 of the document. Said statement has not been disputed by the claimant, and exhibit R2 is a statement of account showing the payment made, pages 59 to 52, 49 to 52 of volume 1 of the document. From these two documents, it is established that the respondent has paid the amount not only to IDBI, but also to the claimant and Sheriff Constructions. There was some loan, my lord, from Sheriff Construction, that also we paid. These payments were made through DD or through RTGS. Exhibit R2 is a statement issued by the bank. Thus, it is clear that as on 3/7/2013, respondent had made a payment of 26 crore 6 lakhs. Thus, as rightly submitted by the learned senior counsel for the respondent, an excess of 1 crore 6 lakhs has been paid by the respondent, which is said to be the interest paid by the respondent. On the other hand, claimant has not placed any documentary evidence in proof of having paid rupees 7.5 crores within 1 year from the date of the last installment of IDBI, and further 7.5 crores within 6 weeks from the date of developer obtained the completion certificate. Though the claimant has adduced oral evidence through PW1 and exhibit R66 to contend that the respondent refused to accept DD was given, there is no convincing evidence on record to show claimant has refunded 15 crores to the respondent. Exhibit 66 only says claimant has arranged funds of 7.5 crores, wants to have a meeting to finalize the transfer of the said fund. Thus, there is positive evidence on the record to show that the claimant has refunded 15 crores to the developer, has not refunded the 15 crores to the developer despite completion certificate dated. Thus, the very fact that the claimant claim petition at para 24, claimant has deducted 15 crores from the total amount claimed itself is proof of the fact that he has not refunded security deposits also. Then, my lord, paragraph 90, 253, my lord, 91, para 91, printed page 45. I'm sorry, my lord, that compilation, probably, my lord, it will come. I have put, my lord, it is.
Yes, just
yes.
was.
My lord, please come to para 91, my lord.
Yes.
The amount of 15 crores sought by the respondent, which is refundable security deposit amount, is concerned in the face of the documents produced by both sides, having regard to the terms and conditions of the development of the agreement as regards the refund of security deposit amount. Respondent is entitled to 15 crore refundable security deposit. Respondent is also entitled to the excess amount collected by IDBI in a sum of rupees 1 crore 6 lakhs. As regards GST is concerned, respondent seeks 2 crores 78 lakhs 53, and in view of PW1 in his affidavit evidence stating that he has deposited before the tribunal a sum of rupees 75 lakhs before the tribunal, said amount can be permitted to be withdrawn, so on, so on. Therefore, my lord, that GST, I'll come to it. Therefore, 1 crore 6 lakhs, there is, my lord, documentary evidence. There was, my lord, consideration by the arbitrator. Argument was arbitrator did not consider it. On the face of it, my lord, not tenable. Then, my lord, the third contention is, please come to page 4 of my note. Sorry, before that, can I also submit, my lord, they have not, Lord, please come to paragraph 2, my lord, at page 3, last 2 lines. At any rate, this is not even challenged by the appellant in the petition filed by him under section 34. I'll point out. Page 324 of the, my lord, that big compilation that we have filed, not only has, not this, my lord, sorry.
Which is the latest?
Filed on 4th.
4th, madam. ಅವರು ಕೊಡ್ಬೇಕಲ್ಲ Leonard, page number, my lord, please come to 324, my lord. Sorry, there are two. ಎರಡು set ಇದೆಯಲ್ಲ? Two sets are fine. Oh. We'll give ours, my lord. It's not fair on our part too. I believe it's gone for scanning, I think, your lordship's copy. It doesn't matter, my lord. We'll just. (324). It starts. That's, my lord, section 34. My lords may come to, my lord, 340. There is, my lord, what is not there, I can't say. Please come to, my lord, running page. (344). No, but then this doesn't relate to the. Well, this is all that they have said. 1 crore 6 lakhs. Please come to, my lord, paragraph 60. Para 60. Order dated 6/7/2003 of the tribunal in dismissing the counterclaim AB is perfectly correct and justified. So that means, my lord, other counterclaims with regard to, my lord, 1 crore 6 lakhs, my lord, they don't have any grievance. But the order rejecting the claim is liable to be satisfied. My lord, his claim and my counterclaim. My counterclaim was allowed. Two of them, my lord, counterclaim A and B was rejected. He says that is justified. The others, they don't challenge. If they have not challenged, then, my lord, they can't, my lord, raise it, my lord, in section, even section 34, they have not raised, they can't raise it in 37.
Who had filed the counterclaim?
I had filed the counterclaim for 15 crores and, my lord, that 1 crore 6 lakhs, electricity, GST and all that.
In dismissing the counterclaim.
A and B.
Probably correct. A and B.
That A and B, my lord, we have not got.
And you have not challenged it?
No. No.
The order rejecting the claim is liable to be satisfied.
Correct. Therefore, implication is.
He would not challenge the rejection of counterclaim. That is in his favor.
Correct.
Okay.
Then, my lord, in the background of this, can I request you, lord, to look at the judgment of the Madras High Court? I've kept, my lord, in the compilation, small compilation that I gave to my lords. Page 91. In this, please come to, my lord, paragraph 3. Page 92.
But according to you, there are no grounds.
That's right. If they have not challenged it, my lord, then how do they come, my lord, challenge it under section 37?
34 not challenged.
No, not only that. No grounds in 37 also, only argument. I point out that also. I put that in on record, my lord. The para 3 of my page 4. Not only the appellant has not assailed the award of interest in the petition filed under section 34, he has also not raised such a ground in his pleading in the present appeal under section 37 of the Act. Consequently, it's not permissible for the appellant to raise in the course of argument contention which is not raised. Division bench of the Madras High Court, in the case of Gopal Krishna Rathi versus Dr. D.R. Palani, R. Palani, reported in 2025, SEC Online Madras 481 has held in para 3, grounds not raised in a petition filed under section 34 cannot be permitted to raise in. That's right. Then, my lord, the third contention, page 4 of my note. Arbitrators awarded counterclaim in favor of the respondent in respect GST, electricity maintenance, clubhouse, and pro rata charges without assigning any reason. Even this is not correct. Please come to, my lord, paragraph 88 and 90 at, my lord, page 307 of this big compilation. Of the big compilation that we've done, my lords. 307. That's, my lord, the award. Please come to, my lord, paragraph 88. Clause 6 of Exhibit P1, the development agreement provides that towards payment of statutory deposit, pro rata charges, owner will have to pay fixed deposit, fixed sum of 250 per square foot or the built up area falling to his share to the developer. And clause 7 further says payment of sales tax, VAT, service tax, and all any other taxes and levies shall be shared by the developer and the owner proportionate to their respective.
The challenge is only on the ground, no reasoning.
That's also not correct.
On the merit of
No,
what has been granted.
no. Even that, my lord, my submission is section 34, I'll point out, not raised. 37, not raised. Only argument they have raised. Then, my lord, during the pendency, in fact, page, my lord, 5, if your lordships come to my note. Sorry. There are, my lord, 307 and 308, and page 5 of my note, if your lordships come to. During the pendency of the proceeding before the learned arbitrator, appellant took 10 apartments, paid all the aforementioned charges, namely GST, electricity, maintenance, clubhouse, pro rata charges. Order sheet maintained by the arbitrator is produced at 255 to 263. That indicates this. In this compilation, we have produced that. So, my lord, they have paid 10 apartments they have taken. They paid, my lord, all this, indicating that they are liable to pay. And, my lord, the contract also provides for it. Arbitrator, my lord, has at paragraph, as I pointed out, my lord, in paragraph 93 and 99, my lord, the learned arbitrator has specifically come to the conclusion that they are liable to pay this.
This 255, 263 of this compilation?
Yes, my lord. That is, my lord, the order sheet maintained by the learned arbitrator. Please come to, my lord, page 256. I'm sorry, I should have put that also. My apologies. I didn't put that. At 256, if your lords has come to.
Of this?
Yes, my lord. That's the order sheet is starts, my lord, from page 255. Please come to 256. Third, my lord, 1, 2, 3, fourth paragraph. Learned counsel for the appellant now submits. Sorry.
Yes.
Fourth paragraph. Learned counsel for the claimant now submits. Documents have been given, now given. It will be verified and GST payment will be deposited before the tribunal on or before 2710. That is in respect to 10 flats. Learned counsel for the claimant submits. Claimant is ready to hand over the respondent the check with respect to pro rata charges 250 rupees per square foot. Accordingly, claimant has now handed over a check of 90,15,750 in favor of the respondent drawn on Bank of Baroda, bearing check number so and so. Receipt of which check is acknowledged by Shri Shailesh Haran. Learned counsel for the respondent submits. So far as GST payable on the account now given to the respondent by way of check is concerned, GST payable on the said amount be kept open to be decided later on. As regards payment of maintenance charges, electricity charges, generator charges, claimant to comply with the order already passed by this tribunal, claimant to comply with the order soon as the keys are handed over, and the claimant should pay the charges. Thereafter, my lord, they pay the amount. So, in fact, again, my lord, please come to page 5, para 4. That is, my lord, Roman 4. There is no challenge to the counterclaim regarding GST, electricity, maintenance, clubhouse, pro rata charges awarded by the arbitrator in section 34 of the petition, nor is there any challenge in the pleading in section 37. In the light of the fact that there is no challenge to the counterclaim awarded by the arbitrator, said contention is wholly untenable.
Yes.
Then, my lord, lastly, 45 documents, my lord, they have not placed it before your lordships. 15 documents we have placed because it has direct bearing and relevance to this. That's all, my lord. And therefore, my lord, in the light of Changalavara and Naidu's case and prestige lights, all that. Anyway, my lord, my submission is therefore, my lord.
Thank you.
I request to have it on 15th, my lord. 15th, my lord, for the reply.
See, 15 may not be possible.
Any shortest date possible, my lord.
Just take it same day, ma'am. How many are there?
Well, that's fine. Whatever my learned friend has given, senior counsel has given, I'll give a reply to that.
Yeah, I have given.
They're given, my lord. Yes, ma'am, I'll confirm.
Lord, can I seek one more indulgence? Can I request your lordship, page 175 of this compilation? Yes. Because counterclaim, my lord, what is it that they had grievance about? Please look at, my lord, page 175, last paragraph. Wherefore the respondent, that's the developer, most humbly prays that this honorable tribunal may be pleased to pass an award against the claimant, declaring the owner claimant share of super built up area, my lord, this A, rejected, B, directing the, my lord, fresh sharing of the apartment agreement, rejected. Please come to my lord the next page. All this is allowed. Page 176, 250 rupees pro rata. C1, C2, sales tax, VAT, GST, taxes, any other taxes. Then D, C3, maintenance charges. C4, electricity charges. C5. Yes, and then, my lord, his claim, my lord, your lordship saw, my lord, he says, I have a grievance against two. Sorry, I have no grievance about these two, but he has not raised, my lord, grievance about the others. That's all that I would say. If your lordship recollects, AB has been rightly rejected, is what he says. He does not say, in going further, that the others, my lord, have been wrongly granted. Anyway, that's all, my lord. Grateful to your lordship.
There's only one respondent.
Only one respondent. My lord, I'm sorry, I've put a compilation of judgments regard to 37. Their lordships of Supreme, my lord, it's like carrying coal to Newcastle, my lord. Yes, grateful. Grateful.
Twenty-seven urgent, 28, 27 urgent, 28.
Sorry, madam.
One second. 24. Interim arrangement be extended.
That's in 26 we are there. Please. 28.
Yes, we are continuing that interim order. Interim order.
Please come to.
Interim order in 20 till the next.
Acha.
Sanjay. 26 minutes we are there. Court officer.
Sir,
26. Please, 20.
serial number 25 urgent, 26. Serial number 26.
The first matter I am for the appellant. In the second matter I am for the respondent. And for the first matter is the ancillary matter, my lord. Second matter is the main matter. No, I will take only 10 minutes of your lordship's time. It's arbitration appeal, concurrent findings.
Half an hour, that's all.
Just re-notify.
My lords, pursuant to the order of the arbitrator, I have deposited 50 lakhs and sought for execution, my lords. That amount is stuck from 5 years. Some difficulty in the matter, my lords. I understand, my lords. My lords, on understanding that the matter will.
36.
Grateful. My lords, in the meanwhile, there is translation. I may be permitted to file paper, but they have not filed it. Yeah, I have translated. I'll file a paper, my lords, currently. Respondent in the second matter. I'll file the paper. Please, my lords. I have filed a compilation of papers, but I'll file a translation. No, next week I'll file it. Please, my lords.
27 urgent, 28. Mahesh.
Happy for the appellant, my lord.
For the
Well, if
respondent.
lordships kindly recollect, the only point of consideration for our lordships, my lord, is whether a party, after having admitted himself to subject a issue in the arbitral proceedings, can he retract it at a later point of time after the order is passed? That's the only question for your lordship's kind consideration. Lordship have heard it. In fact, twice I argued, and I also filed my synopsis, my lords.
Let's wait. Yet
I
to
had
file.
argue.
Well, as the appeal is arising out of rejection of dismissal of the application under Section 8, the contention by the plaintiffs, by the second defendant before the commercial court was that there exists an arbitration agreement between the parties. That there exists an arbitration agreement between the parties. Yes, Malas, he was the applicant there. We have taken three contentions before the commercial court. The first contention is, Malas, the defendant number one, who is LIC, is the main defendant against whom the plaintiff, that is the respondent here before your lordship, have filed the case. And it's an admitted fact that defendant number one, there is no arbitration agreement with them. It's an admitted fact. If I'll show your lordships to the plaintiff.
Yes, my lord.
It will not be applicable, my lord.
It is applicable.
Cox and Kings will not be applicable.
Group
of companies. Here it is not a group, my lord.
In this matter, my lord, why I would submit is applicable because the reason, my lord, the issue arises out of issuance of one LIC policy in favor of the appellant. And appellant was paying it was assigned from the firm, my lord, including the respondents, in favor of the appellant, my lord. And he continued to pay the premium, my lord. And thereafter, my lord, the arbitral dispute arose and it was subject to the arbitration. During the arbitration, my lord, they filed an application before the commercial court for seeking declaration of this LIC policy assignment in favor of the appellant. And in the meanwhile, my lord, they also filed an application before the honorable single arbitrator saying that since this is a dispute arises between the partnership, let it be subjected for this proceedings. And they filed a memo. Appellant also agreed to that, yes, it can be subject to the petition here. I mean, to the application before the arbitration, my lord. And thereafter, the order was also passed by the honorable arbitrator accepting the plea, my lord, that this LIC assignment can be an issue in the tribal before the arbitral. No, my lord, LIC is only they will execute the order, that's all. The honorable, because they have nothing, they only thing, in fact, they have deposited the amount also before the trial court. They are in no way concerned.
My lord, the fact
only thing is they will accept the orders, that's all. They are not concerned, my lord, whether it is assignment or not, no. They have no role to play. In fact, on the last occasion, your lordship was also pleased to say that how LIC is concerned for this arbitration proceedings. Your lordship was pleased to say that on the last occasion, first time when I argued. Therefore, LIC has no role to play.
Yes. Lords, I appear for the respondents, my lords. I am the plaintiff before the commercial court.
No role to play.
No, my lords, the LIC has a role to play because they are the ones who have issued the assignment deed.
No.
It is their policy. May I show you, lordship, the prayer, my lords, in the plaint, my lords? Yes, my lords. We have subscribed. We had paid. Initially, my lords, the relationship between the plaintiff and the second defendant is that of partners, my lords. It is the plaintiff is a partnership firm in which the second defendant, that is the appellant before your lordship, was a partner. But the admitted fact remains that this LIC, even in his application, he admits that the LIC policy, which was initially to a key man of a partnership firm, was allocated to him privately. He says that in the application. So it will fall outside the partnership dispute. Yes, there is a partnership, the partnership deed between the parties, there is an arbitration clause. There is no doubt about it, but it falls outside. Whereas for plaintiff evidence, it has already been recorded. I have led evidence, documents are marked. And my lords, Section 8 is not at all applicable because
he does not file his, raise this objection within his first statement. He has lost that right.
No, my lord.
He
I
does
have
not
filed
file.
this statement. No. Straight away we filed.
20 days period are over. He files an application. Sorry.
Yes,
but my lords, he does not file section 8. He files an application to take his written statement on record. He accepts the jurisdiction of the Honorable Commercial Court, and then when that application is dismissed or pendency, he files section 8, my lord. My lord, so I have not yet filed my synopsis. May I, your lordship?
There's what?
Justice Indu Malhotra's judgment is there, my lords. It's a group of companies.
No, my lord, there is only one judgment because it's a judgment by a learned single judge, my lord, from the Honorable Court of Gujarat, my lord. There, the judgment is that once the party accepts to be subjected to the arbitral dispute, my lord, then he cannot retract it. That's the only point. Because
That's on that point I have submission.
That's the only point, my lord, which therefore I did not. Yes, my lord. It is there,
Unless my contention. No. Arbitration is proceeding. It's for final arguments there.
Arbitration.
That is between the partners. That is for final arguments. Is on assignment before the commercial court against LIC as defendant number 1, who is not a party in the partnership deed.
My lord, I will not disturb my learned friends. I request your lordship to kindly turn to page number 273, my lords. Page 273.
May, sir, I'm not using it. Yes, ma'am. Yes, ma'am. First, plaint is at page number 66 of the appeal memo, my lords. The relief is available at page number 70.
Plaint ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು.
Now, this assignment is issued by defendant number 1.
My lords. Yes, my lords. I mean, their prayers. No. It's them.
Well, I'm the plaintiff.
He is the plaintiff. Yes, my lords. Yes, my lord. Therefore, my submission is that LIC has no role to play. Only the LIC would abide with the order passed by this honorable court. That's all. The firm, my lord. Yes, my lord. Yes, I have that your lordship may kindly turn to page number. Just I will make it very short, my lord. Your lordship may kindly turn to page number 59. Yes, my lord, of my petition before your lordships. Policy, your lordship got it, my lord? Policy under Keyman Insurance Scheme. And your lordship may kindly see the proposer, name and the proposer, life assured, Nitin K. Shah. He is the appellant before your lordships now. He was the partner of the respondent firm. Yes, my lord. Now your lordship may kindly turn to page number 63. Form of assignment of policy for valuable consideration. Vinod K. Shah, one of the respondent. My lord, 63, my lord, Annexure C. You may kindly see the partner, even appellant. No, it's not paragraph, my lord. It is in Annexure C, my lord. My lord, Shalimar is the firm, my lord. Appellant herein and his brother Vinod. They were the earlier partners, and thereafter Vinod's son Alkesh, he also became the partner. Therefore, 3 partners, my lord. And they, due to certain disputes, they said that they have expelled the petitioner appellant hearing, and he has gone to arbitration, is pending there. During the course, my lords, during the course of the arbitral proceedings, this Keyman issue is raised. And now your lordship kindly says, I was 63. Vinod K. Shah, he is one of the partner. He says assignment of policy for valuable consideration. This was in the year 2003, and thereafter, my lord, 13. Thereafter, the appellant is being paying the premium regularly, my lord. And during when it became matured, my lord, they have raised the issues. In the meanwhile, my lord. Yes, my lord. Yes, my lord. They have challenged. They sought the declaration, my lord.
LIC has no role, and it should be part of the same arbitration.
Yes, my lord. For that, I'm sorry to interfere. Kindly, your lordship may pardon me. I would have merits. I will not go on the merits, my lords. I will never give a if this is honorable, I will not go on the merits. Your lordship may kindly turn to page 273. I'll make this very simple, my lord. They file a memo, that is the respondents file a memo before the learned single arbitrator saying that the respondent is filing the present memo seeking necessary orders from this honorable tribunal in the light of certain events which are taken place in suit proceedings commercial OS number 1599 of 2018. That's the present suit which your lordships are considering. Pending the commercial court Bangalore initiated by Shale Maragapati, of which respondents are partners, and the claimant was formerly a partner. The said suit was filed by the firm against LIC and the claimant, namely Nitin Shah. There's a appellant hearing. And after narration, your lordship may kindly turn to next page, my lord. Yes, para 4, my lord. Page 274. It is, may I read, my lord? It is pertinent to mention that the firm filed the suit against claimant as the agreement for assignment was between firm and the claimant in his individual capacity and not based on the interstate dispute amongst the partners. The suit was also filed as LIC is a third party to the partnership firm and for the purpose of first relief sought therein. LIC is a necessary party. The firm filed its objections to IA number 3 questioning the maintainability of application as being belated and unsustainable. Copy of the objection is produced so and so. In the above proceedings, although the respondents have referred the issue of Keyman insurance policy, they have not raised it as a dispute and sought any relief as they had already filed the said suit and my lord. Yes, my lords. Under the above said, just about that, my lord, kindly. Some 4 lines. However, the respondents are willing to get the Keyman insurance issue subjected to arbitration before this honorable tribunal, subject to the consent of the claimant, in which event the respondents will withdraw the aforesuit. Since the claimant has filed an application section 8 of arbitration consent, which is meant for reference of disputes to the arbitration, it is presumed that the claimant would have no objection for subjecting the dispute of Keyman insurance policy to arbitration before this tribunal under the circumstances. So they very clearly speak about the suit and the application which under challenge before lordships, they will say, okay, we'll subject here only. And LS has no role to play. For which, well, they also annex in the next page, 276, they also annex the plaint, my lord. And we also file a objection, memo for consent, 277, my lord. Appellant files a memo saying that yes, we consent for this issue, Keyman issue to be subject. They said page 280, my lord. Para 5, on this issue only, on this memo only, my lord. Shri Mahesh, there also I am appearing, my lord. Learned counsel for claimant submitted that claimant has no objection for subject Keyman issuance policy to arbitration before this tribunal, subject to condition that respondents 1 and 2 withdrawing the suit, OS number so and so pending before. Because I will just, you all should be kindly see, I will come to there, my lord. And next 3 lines, my lord, thereafter, the issue of Keyman insurance policy in order to be made a subject. Lordship is a definitive order. Same page, 280. Some 5 lines below, my lord. In the light of this memo dated 5/1/2021. Yes, my lord. So there's a definitive order. This order still exists. It is not set aside. You also may kindly see. Thereafter, 282, my lord. Page 282. 82. The respondents would file additional memo 1 and 2 by pursuant to the memo dated so and so. And page 283, my lord. Page 283. While filing memo dated 5/1/21, your worship, but it, my lord. I hope I'm not fast, my lords. While filing memo dated 5/1/21, it was thought that the issue of Keyman policy could be resolved between claimant and these respondents. However, on a detailed analysis of the facts and understanding of the applicable law, adjudicating the Keyman issues policies without dwelling in the LIC would lead multiplicity of proceedings. Under such circumstances, the respondents withdraw the memo dated 5/1/2021 and would contest the suit, my lord. Now there is no order passed by this. The order, the respondents.
Let's fair for it.
First they say yes, we want, order is passed. We also said yes, and order is finalized. There is no, on this memo, there is no order passed. It was pending. They also mentioned, as I read out, my lord, in their memo, they mentioned, yes, there's an application section 8 pending. So during the pendency of the,
No, my lords, may I continue? There is a subsequent order of the arbitral tribunal, which we have produced in our response, my lords.
That's good.
At page number 30, my lords, in the counter affidavit. My lords, this is an order on IA number 18, my lords. In that, my lords, in that order, my lords may see paragraph number 11, my lords. At page number 38, my lords. May I read that, my lords? Which is the last order on these memos, which is the actual order on this. In the 14th meeting of the arbitration held on 9/1/2021, the learned counsel for the claimant submitted that the claimant has no objection for subjecting of the issue of keyman insurance policy to arbitration proceedings before this tribunal, subject to respondents 1 and 2 withdrawing the suit in OS 1599 of 2018. In light of the said submission, memo dated 5/1/2021, filed on behalf of respondent 1 and 2 came to be allowed, and the issue of keyman insurance policy was ordered to be made a subject matter of this arbitral proceedings, in addition to issues already raised in the pleadings by the parties. Respondent 1 and 2 were permitted to bring on record necessary plea in that regard by way of amendment of statement of objections / counterclaim. However, on 28/2/2021, an additional memo came to be filed on behalf of respondents 1 and 2. It was stated that on a detailed analysis of facts and understanding of the applicable law, adjudicating the keyman policy issue without involving LIC would lead to multiplicity of proceedings. Therefore, respondents withdraw the memo dated 5/1/2021 and would contest the suit in OS 1599 of 2018 on merits before the commercial court. Thus, though at one stage an attempt was made by respondent 1 and 2 to make the issue regarding keyman insurance policy as subject matter of this arbitral proceedings, subsequently it was withdrawn. In view of this, the purported disputes regarding... Sorry, my lords, the respondent 1 and 2 was permitted, but that order was withdrawn later on. The tribunal himself, the tribunal records that. Sorry, my lords. Page 39, my lords. Yes, my lords. I'm sorry, my lords. Page 38, my lords. Paragraph 11. I was reading that paragraph, my lords. Because this is after what my learned friend has read out that order. This is the subsequent order where the tribunal itself says that this keyman insurance is no longer part of the arbitral proceedings. It doesn't fall within the realm. My lords, there is one more development after this, which, my lords, has not yet been placed by way of a memo or by the fact remains is after this, my lords, both parties went before the arbitrator and also limited the scope of inquiry to only 4 issues. Issues were recosted. A joint memo was filed, which was signed by both the parties saying, we will only decide, not including this. Which is why I was saying, my lords, I want to bring that on record by way of synopsis.
My lords, may I kindly see?
And that has not been challenged. Neither this order is challenged, nor that order.
I will answer, my lord. This order, which my learned friend is referring.
May I make one more submission?
I'm sorry. You finish.
One more submission. Sorry, my lords. Lords, on one hand, the appellant says that the commercial court does not have jurisdiction on one hand because of whatever transpired before the tribunal and undertaking given by the tribunal. But please see, my lords, the appellant before the commercial court itself files an application saying that the matured amount please be deposited before the commercial court. If he is not accepting jurisdiction, the application ought not to have been filed, and the application is allowed. Now the money is deposited before the commercial court. That also, my lords, I want to place that order before your lordship. So having accepted,
let him finish.
Sorry.
I will come to that, my lord. Joint memo was filed subsequently while this petition was pending. Once, if this honorable court accepts our plea and says that yes, this issue of keyman can be subjected to the arbitral dispute, it's a separate issue. It cannot be mixed at this stage, my lord. We are only concerned about the main issue over there. For that we consented because this matter was alive for lordship to kind consider. And so for the order is concerned, my lord, what my learned friend is saying that an order on memo is false. It is not correct, my lord, because of simple reason. You lost may kindly turn to page 32.
May I produce those
Yes,
documents?
no,
sir?
I
And
conclude,
the
my lord.
recording of the
I will
tribunal.
conclude. Your lordship may kindly turn to the order which he just now read out, my lord, page 32 of his objections.
It is in existence, man. It's not challenged. They have not challenged.
No. We need not challenge because of simple reason. Your lordship may kindly see this order is reads this. In this application, your lordship got it, my lord? Page number 32. In this application, it is IN number 18. In this application, respondents wanted to have sought for permission of the tribunal to operate the account number so and so. It is not on regards the memo. It is not on that. Eventually, it is dismissed. As a passing reference, this observation is made. So this cannot be considered as, but page 32, just of what my learned friend Arya, read out, my lord, saying that an order is passed on Keyman Insurance. My submission is it's not an order. It cannot be considered as an order, my lord. Because of the simple reason, this is
39.
39.
Relevant
39,
question
my
is
lord.
39. Starts from 30.
Of the objections. Annexure or 3. You lordship got it, my lord? No, first paragraph I am reading out, my lord. First paragraph. To show. No, that is para 11. I am not on that. On the order passed is an observation. There is no finality of the memo, my lord.
Yes, ma'am.
It's a fact that this insurance policy is not subject matter of arbitration.
Correct. Yes, ma'am.
That is what he is narrating.
Yes, ma'am.
This is what he is narrating, the arbitration. This is not subject matter.
Yes, ma'am.
Till such time, maybe the order which was passed where the consent was given.
Yes.
To make it a part of the arbitration.
Yes.
Or section 8 is allowed to become a part of the arbitration.
Because this order was after all that, my lords. This order was after that joint memo.
Right? After that.
After that.
But it did not go. You sought the recall.
Yes.
You sought the recall. Who sought the recall of the order?
No, we have
They
not
only.
sought any recall.
They
my
only.
lords. We have not
They
sought.
filed a
There is no
retraction.
recall application. my lord.
You did not take it further, that order.
No, my lords.
To make that insurance policy part of the arbitration.
Yes, my lord.
You did not take it further.
No, we filed a memo saying that that undertaking is withdrawn. Based on that memo of undertaking, this is the order.
No, my lord. That is not based on that. I'm
Actually,
sorry.
sir,
I'm sorry. It's under the
may I
IA
narrate the
18.
dates, my lords?
IA 18, my lord. It's on IA 18. to
Nevertheless,
operate
my lords, after this, there is a joint memo filed by the party saying only these issues will be resolved. And those issues do not cover Keyman Insurance. Yes, my lords. My lords, withdrawn by us. We withdrew our undertaking. My lords, initially. Yes, sir. Effective.
Then say, in view of this, the purported dispute regarding human insurance policy is not
Yes.
the subject matter of the arbitration proceeding.
Yes,
So what he says is, regarding respondent made, effort was made by the respondent wanted to make the human insurance subject matter of the arbitration proceeding. It was withdrawn, and hence the human insurance is not part of the subject matter of the arbitration. It's a fact.
It's a fact.
That's the reason you are here.
Yes, my lords.
Both of you are here.
Yes.
Because of that.
Plus, one also, another fact which is yet to be placed, my lords, is the joint memo filed between the parties. Apart from this, there were around 10 to 11 issues, my lords. Yes, my lords, LIC is a party.
LIC
Because
has
the
been-
arbitration proceedings has reached at the stage of final arguments, my lords.
My lord, LIC has deposited the money. They have nothing to do with it. They have washed off their hands.
No, they have not washed
My
off.
lord,
They have
money
filed
is
written
deposited.
statement.
It's only direction. They will abide by the direction, whatever direction given by the courts. They will not even contest. Is between the parties. That's what they precisely, rightly they have said in their memo. Very rightly they have said.
My lords,
It's between the parties.
my lords must see section 8, my lords. If my lords must see section 8, my lords, even
My lords.
Lords, may I-
Before this honorable I court, my lord, in 2017 only, my lord. No, my
No, it
lord.
is
Before the
not
arbit, we have not filed the written statement, my lord. Yes, my lord. There is no written statement, my lord.
Now, after the written statement, you sought, according to the counsel, you sought for taking the written statement on the court.
Yes, my lord.
That will not
Yes, my lords. Yes, it is not permitted, it is rightly rejected.
After that, you file a section.
Yes, my lords.
How would you answer that?
Because, my lords,
Possibly you find judgments also.
very well, I will look into that.
Section 8 is only as an afterthought after the right to file section written statement got rejected or forfeited.
I will show one particular paragraph in the claim petition and objections, my lords. After that, I will conclude my arguments. Your Lordship, may kindly turn to page 108, para 28. It is not that this was alien to the proceedings. Page 108, para 28, my lords. Your Lordship got it? Please. Please, my lords. It is submitted the claimant was the main person for management and marketing of the firm, and hence the firm had taken keyman insurance policy in his name. This kind of insurance is taken only against key personnel or the key partner. So it's clearly evident that the claimant is the key person for the business of the firm. Continues to pen. However, unilaterally, without the knowledge or consent of the claimant, the respondent informed vide email dated 2517 that he has debited an amount of rupees, file close 20 lakhs. He has not questioned the email, LIC policy matter from the account of the claimant, to which claimant has made reply stating that so and so. Yes, my lords. Now it will be enhanced. Now your Lordship may kindly turn to their objection.
In the commercial court.
Commercial court. Therefore, I submitted. LIC has got nothing to do with it. They are absolutely nothing. For this, your Lordship may kindly turn to the. We failed. We did not. It was required.
Section 8 is.
Yes, my lords. That was not. That is the reason. Anyway, whatever the reason is, the reason remains at that point of time. Nearly for 1 year, there was a negotiations of settlement. That was the reason. In fact, I told my client also, we will file a formal written statement. He said, no, it is going to be settled. They're between brothers, my lord. Yes, it's the blood. Your my colleague turn to page 120.
How would you answer this?
There, I got little Asians heels, my lords. Yes, my lord. For
yes,
yes, my lord. I am.
Allow 120 days to lapse. And then, as it invited, possibly judgments are observations are only to now obviate because your right to file written statement has been
Woman. It appears like that only. Whatever.
Suppose you had filed a written statement and minded according to him, you filed an application
to bring it on.
Permission. If that is so,
It's a fact, man.
if that was to be allowed, where would your section 8 go?
Yes, my lords. Yes, man. But since
my lords, could
my
he
lord
have
question,
filed
my
an
humble
application
submission
to
is,
deposit the money,
it
my
cannot be taken as a waiving of the right to approach the. And moreover, my lord, it is not me who went to the honorable tribunal saying that make this issue as a policy. Issue there. It is them who went there. Therefore, my lord, when they want, they went there. They said, you please make this LIC.
May I make?
No, my lord, it is there still. And what observation he made, he is trying to say it as an order. My humble submission, no, that was for IN number 18. In objections, man. Yes, my lord. Page 39, they filed an application. Order on IN number 18, filed by the respondents, my lords. 30.
Plus page number 39, my lords.
Order.
Order. Okay.
R3. Annexure R3, my lord, after the objections. R3. Page would be a 32, in fact. I think it is 32, my lord, because there's a
The observation is at page number 39. It commences at
32, my lords. Page 32.
It commences at page 30, my lords. 30, no, 30.
It's the last document of the statement of objections. But I think there is some mistake in the pagination.
Good.
This is the last annexure R3, my lord. Yes, ma'am. In annexure R3,
See that page 59. Just read from the bottom of the page.
yes, my lord.
Thus, though at one stage an attempt was made by the respondents one issue regarding human as subject matter of arbitral proceedings, subsequently it was withdrawn by them.
Yes, my lord.
It's a fact.
It's a fact.
Now, what is the intent of the learned arbitrator? We don't know.
Please, my lord.
He wanted to make it his order, or he is narrating a fact.
Narrating a fact. This is my submission. Because you also may kindly turn to page 30. I'm sorry.
Let us read the whole. Sorry, ma'am.
The purported dispute regarding is not our matter of arbitral
Proceedings. Yes,
He says so.
he says so.
So today, the situation, position has not improved. It has not become. You are here before us to make it to be part of the arbitral proceeding.
Simple.
Therefore, it is not proper to make an observation of the contention
Yes.
on both sides with regard to the assignment of policy in favor as well as in non-favor.
Yes, ma'am. Now, this was an observation, not an order, because the reason this order was on IA number 18. You also may kindly turn to.
How would you answer this filing of section 8 after
That I am little on a backtrack, my lord. I agree. I will look into that, my lord. I got the.
There is.
and possibly the observations are on this. Not here, you will check up.
I'll-
High courts have passed.
I'll check.
Please, my lord. We'll assist the court, my lord.
Was that apart, my lords, what I started off by saying, my lords, irrespective of these submissions, my lords, the fact remains subsequently, about a year later on, both parties that are before your lordship have entered into a joint memo narrowing the scope of inquiry before the arbitral tribunal.
Because, my lord, this was pending before this.
No, no, my lords.
What will you say? Without prejudice?
No, that we are not said, my lord.
Your rights and contentions in this appeal?
No, we are not said that.
No, no.
We are not said that.
Tell us legally what would be the best way to put it. So that he would be obviated from making this submission today. Based on that joint memo, and he is relying upon his.
Yes, my lord.
You could say, without prejudice to my rights and contention in this appeal.
I would.
I am agreeable to this.
I don't think so.
We have not said so.
We have not said so. I think we have not said that, my lord. I'm sure.
Look into this.
I will look into that, my lord. Sure. Grateful, my lord.
Just say that the joint, that the request of joint request.
Joint.
Joint request of the council. Please, we want to go beyond the
Please, my lord.
That's may I be granted liberty to bring those documents on record.
Just think over it, both of you, I think you want that to be here or.
My lord, absolutely, no process will be caused if you go back to arbitral dispute, because all the materials
That's
are
what
there,
will
every
happen
material
is-
is there.
2018, the
Absolutely.
arbitral tribunal was set up. Yes, sir. Lords, the arbitration is the stage of final arguments, my lords. Now again, to go back to pleading stage. Great.
Grateful, grateful, grateful.
36,
36.
23, 6. 23.
23.
Little, maybe in the first week, my lord. Of course, I cannot. Because practically, we have completed our arguments and nothing much for us to argue. Grateful.
Grateful.
13, 6. Serial number 29. 29. Somebody mentioned.
For the respondent in the connected appeals, my lords. In the morning, we attempted mentioning, I have informed the other side. Difficulty.
My lord's hands, only thing is, my lords. Lords, my only request, lords.
Yes.
Please, yes, please, my lords. The reason, my lords, is only this. The matter is coming up, my lords, on the 9th, and the matter is proceeding because, my lords, there is no order of, my lords, stay of, my lords, the proceedings before the trial court. The issue, my lords, is also, my lords, within a very narrow compass. There were, my lords, applications filed, my lords, under Order 7, Rule 10 and Order 7, Rule 11, which, my lords, came to be rejected. As far as the 7 Rule 11 application is concerned, my lords, I may not press, my lords, to this thing. The 7 Rule 10, my lords, is something that, my lords, I would press with regard to the jurisdiction of the court. Territorial. Please, my lords. My lords, there is no clause. What has happened, my lords, is this. Could I just request, my lords, to look at the... this was, my lords, an equipment purchase. The appellant, who is, my lords, the defendant in the suit, is, my lords, in Kota, Rajasthan. The plaintiff, my lords, the respondent here, is, my lords, in Bangalore. The entire issue, my lords, revolved around the purchase, my lords, of certain equipment by the appellant in Rajasthan from, my lords, from the Bangalore this thing. Now, my lords, they claim, my lords, that there was this equipment purchase agreement that was, my lords, signed by them and sent to us, which was never signed by us. In fact, my lords, they admit so, my lords, in the notices that are exchanged between the parties. Now, despite that, and there have been, my lords, previous transactions also between the parties. So there were, my lords, certain MOUs that were executed for certain previous transactions. Those MOUs did not have, my lords, jurisdiction clause. This equipment purchase agreement, which they claim to have sent and, my lords, was not signed, that supposedly, my lords, has a jurisdiction clause, my lords, of Bangalore. Now, the trial court, my lords, confuses the whole factual matrix and says, well, you've signed the MOU. The MOU has this jurisdiction clause. Therefore, Bangalore has jurisdiction, and, my lords, dismisses my application. Lords, my respectful submission is, as far as, my lords, the equipment purchase agreement is concerned, I have, my lords, not signed it. It, my lords, is not an agreement that, my lords, binds me to say, my lords, that Bangalore has jurisdiction. Insofar as, my lords, the other indices, which is, my lords, they say that there were, my lords, notices that were, my lords, exchanged that were received by them in Bangalore. They say payments were received by them in Bangalore. They, my lords, as far as the equipment itself is concerned, they don't say it was supplied, my lords, out of Bangalore.
Exactly would be the focal point, which will make Bangalore not a jurisdiction based on invoking the how do you answer?
Lords, it will be Kota, my lords. Lords, one is there is, my lords, already a suit that, my lords, I have filed that is pending, my lords, before the Kota court. What had happened, my lords, was that since these are commercial matters, my lords, and this was, my lords, way back, my lords, in 2018, I had, my lords, filed, my lords, pre-institution mediation. That is, I had given, my lords, notice and all that. Of course, at that time, it was not, my lords, in the strict sense of the term mandatory, because Supreme Court, my lords, says that it is prospective from 22 or 23, whenever the judgment came out. But, my lords, I had followed that. So when I issued, my lords, that pre-institution mediation notice, they, my lords, institute this suit here. And of course, once, my lords, mediation failed there, I instituted it, but there was it. They have, my lords, those proceedings are going on. They have, my lords, in appearance there as well. Pre-institution, they appeared. My instructions.
I'll take instructions on whether we appeared in the mediation, my lords. Please.
Still there are others which have come. So we are submitted to the jurisdiction of that mediation or legal services authority of which Kota is the jurisdiction.
I understood.
That we show, can this court have a jurisdiction?
Please.
Possibly you can argue, possibly you can argue. He is denying it. That's based on a memorandum of understanding. Bangalore was made a parties have agreed. Two places have jurisdiction. One place is Bangalore. Before that mediation had taken place. But even despite that, we have submitted to the jurisdiction of that mediation.
I perhaps cannot raise a question of jurisdiction in mediation, my lords. Please.
See, you're right. But having appeared in that mediation, legal services authority would be coming within the jurisdiction of Kota court.
Please.
If that be so, how would you answer?
It was not even a pre-institution mediation in the strict sense because the 2018 rules weren't even notified or well hadn't even come into force. I'm not entirely sure under what jurisdiction.
Courts Act itself. 12B.
Please. What happened thereafter, my lords, they filed an application before the commercial court again saying that their suit is the first suit. The court considers all of this aspect and dismisses their application saying, no, my suit is in fact the first suit. That finding is also there already and I believe that has not been challenged. What is also of consideration, my lords, this is an appeal under section 13. An order under 710 refusing to return a plaint is not an appealable order under 43 of the order 43, my lords. It is only when the plaint is returned, my lords, under 43(1)(a is an appeal maintainable under 13.
I'll just not.
In fact, this court also has.
I'll not.
Says a mandatory. This 43 only confined to the is only confined to order 43.
I'll not.
I have an order of this court, my lords. I'm not entirely sure if that is the judgment my lords are referring to. There is no reference to the Supreme Court. I'll examine the Supreme Court judgment. I would submit both appeals are hit by the requirement, my lords. In fact, it is a order dismissing order 7 rule 11.
Only one eventuality is contemplated.
Please,
That eventuality is rejecting 710.
please. Then it will be a regular appeal under.
Is it allowing or rejecting 710?
710 only allowing, my lords. It says returning a plaint.
Because intent is because of allowing is going outside the jurisdiction.
Please,
But if it is rejected, the suit remains in the same court.
please.
So you will withdraw the other appeal?
Lords, could I just, Lords, on the next statement, Lords, I will just, Lords, get instructions. I'll Lords.
We'll examine and place it on record.
Please, Lord, please. Please.
Please.
25-4. Seal number 30. Judge.
I'm appearing for appellant, Your Lordship. I'm appearing for respondent, my lord. Your Lordship, the settlement talks almost reached finality. We have proposed it. So they need to finalize it. There is a between 10 to 12 lakhs differences. It might be get settled on next date.
You are settling the matter.
Yes, ma'am.
For the parties, the parties are excluding settlement. They requested to.
Ten-6.
Grateful, Your Lord. Grateful.
What are you doing, Mr. Chadda? What are you doing? Your brother. You're recording it? No. Don't do that. You can check me. Don't do that. You are getting that impression, that's all.
No, sir. I was just checking one location. You can check it.
Video alone.
You check it.
Okay.
Don't use the mobile, sir.
Never.
Seal number 31. 31, Ranjan Kumar.
Filing memo for withdrawal.
Thirty-two, Shri Vinay.
I'm for the appellant. I pray for time to file affidavit. The authorized signatory was out of station, my lords.
My lords, make
Short
one request, my
accommodation.
lords.
My lords, in the trial court, it's matter listed on 15. 13, sorry. My lords, any short accommodation?
18-6.
I may make only one request, my lords. Rightly or wrongly, my lords, I am in there's a judgment in my favor. Until, my lords, that is decided, let them not use the word mark, my lords. Because keeping this appeal in pending, my lords, they continue to still use the word mark. Till then, let
My
them not use
instructions,
it. That's,
They have stopped using it, and
my lords, the name, my lords, Krishvi, if my lord sees the cost title, it's a similar mark. My lords, they services, my lords.
service. My lords, my instructions are that they have stopped using it.
Yes, my lords.
My lords, I will seek instructions and I will record it. My instructions are there.
You say both.
Yes.
My instructions are what I take it. Go and then take instructions and pass it on. Take instructions.
My lords, any.
Right, which is in his favor.
Yes.
Go in time. Go.
The exhibition case is on 13th, my lords. Any shorter accommodation maybe?
You will say, you will record it. Your submission that they are not using it. You will record it. Are you using or withdrawing?
If they are not using, I won't press the execution, my lord. Let the statement get recorded. I'll take an adjournment.
Oh.
To that extent, if you are not using it, we will not press that execution also.
Okay, my lords.
Then we will decide your rights here.
I will seek instructions.
When will you take it?
And we have
Today
to
itself.
move.
Oh.
Okay?
Okay.
Still number 33.
Just one point, my lord. My lord, the question here is there was an agreement for specific performance. The appellants are the landowners. Our contention is that the respondent was not ready, let alone willing to perform his part of the contract. We are governed by the old specific relief act. He had to plead readiness and willingness. What he does is, he comes and leads evidence. Then out of the blue, he brings a witness, one called Srinathan. He says, yes, I have got an arrangement with the purchaser, that is the respondent. I am ready to give him the money. My balance sheet is this, no bank accounts are produced. The learned arbitrator says, you have not said anything about this. You have not shown that he was not ready and willing. My only submission is, Srinathan was a person who was neither named in the claim petition. It was not named in the claim petition. He suddenly comes forward and says, yes, he is a rich man. He belongs to the C. Krishna Chetty Diamond Jewelers Group. Balance sheets are but there's no bank statement, nothing is produced. The learned arbitrator takes his evidence and on that basis, allows the specific performance. This is all the case. Lots may see. Paper books are filed.
How long it would take?
40 minutes, 30 minutes, 35 minutes. Very well.
They have undertaken not to press the execution.
Very well. In any date convenient to the court. My lord, there was some interim arrangement, they would not precipitate. I think that continues.
It's not a part of the order.
No, I think it is there in the order. They would not precipitate.
Execution will not precipitate at the undertaking.
We have given, my lord, we will not do it.
Sale is taken.
It's all right. It's only at the stage of the sale.
Is it part of the order or not? If it is not just an oral understanding,
We'll not continue that one. It's all right.
Oral understanding. Very well.
No, I'll.
Once Mr. Valla says it's sufficient for me.
For the last 1.5 years, we have not done.
next.
34 urgent. 35, Mr. K. Narasimhan.
Kindly pass over, man. Pass over. Publish.
36, Mr. V.S. Naik.
Kindly pass over.
Next.
37,
For respondent minutes.
38,
Happy for respondent to this matter. Notes in this matter.
Next year.
pass over.
Pass to.
There you will argue.
38,
Happy for respondents, my lords.
We are passing it over. We have passed over the matter.
Passed over after lunch.
It will come after lunch. Okay.
38,
Happy for respondent, my lords. My lords, in this matter, I want to file objection and produce one document, my lords, that they are not. Please, my lords. Much.
18.6, 39, 14%. Chandrasekharan.
Yes, my lord. I am party in person.
Yes, what is the issue, Mr. Pilgrim?
I have only one issue. It is upgradation of my ward entitlement from semi-private to the private ward. There was a letter from Government of India stating that after the implementation of Seventh Pay Commission, this has been amended. Earlier, I was getting a semi-private ward on my retirement. So after that, government has issued a letter stating that this has been basic has been reduced. Earlier, the basic pay was for a semi-private ward, it was 65,000 basic. They have reduced. There was some anomaly. They said in the letter there is an anomaly. So we are reducing to 50,000 onwards, 51,000 onwards. It is a private ward. So may I kindly see that letter, Your Honor. So based on that, I have applied for a revised CGHS card, which has been rejected by the Deputy Director Bangalore, CGS Bangalore.
What have they done? They asked them to file a
Detailed
detailed order.
order is CAT has given a CAT in the CAT order. I went to CAT. So CAT has said to consider the application.
That's right. What is wrong with that?
So CGHS has not considered my application.
File a content before there. File a content before the.
No, they have given a detailed letter. As per these are the letter. It is a in Annexure B, Your Honor.
This is what they have given.
Yeah, they have given a letter.
Challenge this letter.
This is actually I want because I was getting the after pay commission only I have retired.
Have you challenged this order, letter of 11/9/24?
No, that I have not.
You must challenge
in the same cat.
in the same crime. You have to challenge that. They have rejected you.
Yeah, they have rejected.
You will go to the tribunal again. We will say so. Okay? But this will give you a fresh cause of action.
Okay.
Let's say this, the challenge in this petition, these two is 924. And no, 23, 10, 19, 23, 10, 24. Passed by the. What is this 23, 10, 24?
23, I asked this my representation again. In that same order, they have given a copy of the same letter in the annexure C.
Just say this, the petitioner has filed this petition with the following prayers. The user of the prayer clause will be the petitioner is in fact challenged, has not challenged the order of the central administrative tribunal. The OA number 170/00/081.
481.
But has challenged application dated 11/9/2024 and communication dated 23/8/2024. Thereby the respondents have rejected in pursuant to the order passed by the Central Administrative Tribunal in the aforesaid OA dated 9th August 2024. Today order dated 11/9/2024 and which order was again communicated to the petitioner in terms of the covering letter dated 23/10/2024. That we saw, the petitioner is required to challenge the order dated, communication dated 11/9/2024 before the Central Administrative Tribunal. Accordingly, the petitioner is granted and we find that the present petition has been filed in this court on 8/11/2024, granting liberty to the petitioner to approach the Central Administrative Tribunal. Central Administrative Tribunal by filing a fresh OA challenging the order dated 11/9/2024. We close this petition, but making it clear that the petitioner shall be entitled to the benefit of Section 14 of the Limitation Act. While the tribunal computing the period of limitation in filing the OA before it, challenging the order dated 11/9/2024.
I'm for the petitions. No, it's the same case where similar to compulsorily retired from service, my lord, on 1802A of Indian Railway. Please.
19/6.
Meanwhile, interim arrangement which is existing as on today may be continued.
For that inquiry officer.
Please.
We have said so or your statement?
Initially, it is my statement.
We notify of the statement given by Mr. Shantanu on 25/9/2024 shall continue both the matters shall continue till the next date.
Much obliged.
Great.
41.
I appear for the respondent in this matter.
And for the appellant in this case, my lord. My lord. In this case, I just want to take the attention of this honorable court on order 28/4/2014, my lord.
this honorable court has on 23/4/2014, this honorable court has directed to call for the trial court record, my lords. On 28/4/2014, the document has been received in this case, my lord. But when we applied for the certified copy, we are unable to get the exhibits, my lord. There is no certified
We
copies
already
before
furnished
this.
everything to them.
No, my lord, we have received only partly C series, my lord. Respondent series are not there in this record, my lord. May I take the honorable court in the main petition?
It is just one excuse after another.
No, my lord, there is no any excuses in this, my lord. Without document, we couldn't give the
Lordships may
proper.
kindly,
I'll just take, my lord. I'll not take much time, my lord. Just to bring before this honorable court, the documents are in records. The trial court documents are not here, my lord. May, my lord? Paper book is filed, my lord, but no exhibits are filed by us. Deposition is filed by us. We have collected few documents from them. Undoubtedly, they have given, but no documents have been filed. No documents are there here also, my lord. May lords may look on that. My lord, without document, I couldn't commence my argument. I seek for. But if this court director will get the documents, my lord. We have applied, my lord. There is no document.
What can we do is in the trial court or here, this court? What do you say?
The records have been received by this court, my lord. The record is very clear, my
Are the
lord.
exhibits here?
yes,
No. What is this? Just check it out.
There is no series in this, my lord.
Let the court officer check up also. We will also check up. What are your instructions? What do you say?
Lords, we are ready, Lords. We have been ready on the last 20 occasions also.
Just say that
Lords, your
just say
Lordships may
that the
fix the date.
trial court record has been requisitioned, stopped, and a counsel for the appellant state that she intends to apply for certain certified copies of the exhibits as shall be there in the trial court record. At her request, re-notify.
19/6.
Please.
Please, my.
Great.
We'll come back after.
Please.
42 in the.
Yes, ma'am.
Serial number 42, Srimati Vanita K.
Yes. Who is for the appellant? And last time also they were not there. You say none for the petitioners. There was no appearance for the petitioner on the last date of hearing. Dismissed in default and non-prosecution.
43, Shri T.C. Gupta.
This is also this regularization.
No, my lord. This is reservation for promotion.
Is this issue not settled, Mr. Gupta? Is this issue not settled?
Not settled, my lord.
Why?
In this,
Where is the reservation on promotion?
at that time it was there.
Now there is a constitutional amendment. Just show us the constitution. There is a constitutional amendment. What does the tribunal say?
In this case, the issue was that there was one departmental examination of ITO. That examination was one time, and as per rules, that examination was to be qualified once in a service. For normal candidates, the passing marks were 50%. For reserve candidates, passing marks were 45%. It was only qualifying. The issue was whether this lower marks can be considered as a relaxation for promotion. If it is not considered as a relaxation, then the applicant petitioner was to be considered as promoted on his own merit.
But this is a relaxation. This is a relaxation.
And that has been defined by the DOPT.
That's right, but then it is not on merit.
No, DOPT has defined that it is not relaxation for this purpose.
They have defined?
Yes, my lord.
Show us.
Yes, my lord.
Then what is on merit? Merit means if he gets 60% marks, though a reserved candidate, he is on merit.
He will be promoted on his own merit,
That's
along
on
with
merit.
general candidate.
That's right, that's on merit.
Yes, my lord.
But the moment that he gets the benefit of relaxation, then it cannot be said on merit.
But as for DOPT instruction, this is not the relaxation for the purpose of
Show us, show us.
Yes, yes, my lord.
How many marks he got? How many marks he got?
Not 50.
Not 50?
More than 45. Madam. This is DOPT instruction on this issue. The department has referred to the DOPT to clarify the issue.
So, see the paragraph 4,
Yes, my lord.
the highlighted portion. The paragraph which has been quoted. Paragraph 4 of the first page.
Yes, my lord.
To determine whether SC/ST candidate in the consideration zone can be promoted or not, when there are no reserve quote, it should be seen whether the candidate would have been promoted if he did not belong to SC or ST category. If yes, he should get the promotion, and promotion, otherwise not. So means if he gets the promotion, though there is no reserved quota,
Yes,
belonging to SC/ST, then he should get promotion, otherwise not. It doesn't talk about relaxation. See, what is the purpose here is, there is no post needs to be filled up through SC/ST. He is in the zone of consideration. He is being considered and he is found fit for being promoted.
Yes.
Not against SC/ST post, nor against a reserved quota. Then it is on merit.
Yes.
It is that situation which is contemplated. But here we are putting it to you in the context what you have said. In the context what you have said is, if there are relaxed standards and a person is availing relaxed standards and getting promotion, then it would occupy, like, you know, this famous judgment of the Supreme Court in
Nagraj. Nagraj.
Nagraj is on a different path, where they say if the quota is achieved, it will start operating. So if he is getting on a relaxed standards, then he would be occupying a reserved quota. That's the intent. It is not such a case that he got more than 50 marks, he got promotion. Then we are with you on that. It is not such a case. So he got something less than 50, because of which he got promotion. So he would not occupy the merit point or a general category post.
No, but because he got less than 50 or 60% marks, therefore he was not promoted.
He was not promoted. He was not promoted means he did not get even promotion under the reserved also.
Yes. No, there was no reserve point.
Oh, there was no reserve point. Yes. Then tell us one thing. Now, if you see this, what has been said, if there was no SC/ST reserve point, if he had got promotion, provided he got 50 or above, to consume a general seat.
Yes.
Since he did not get 50 and above, he could not have got the general seat. That's it.
No, but the issue is,
that's annexure A. He secured marks under reserved category. Annexure A, my lord, page number 57. Relevant page is page number 64. Annexure page A3, my lord, page 57, it begins. Lord, relevant page is where the name of the petitioner finds.
Which page? Which page?
My lord, 57 of the writ petition, my lord.
57.
Please, my lord, annexure A begins. My lord, relevant page is page number 64. My lord, serial number.
Serial number?
34 in page number 64, my lord.
Yes.
Lord.
Anjana.
Please, my lord. Ajanna.
Ajanna.
Please, my lord.
ITI ST belongs to ST.
My lord, he belongs to ST, my lord.
48, 44.
Total is 92. In the first row of the page 64, if my lord sees, my lord, that clarifies.
L1, L2, SC/ST 45.
Please, my lord.
General is 50.
50. Total is 50. My lord, his total is 92. If my lord sees the serial number 34. Lord.
What is AC? Heading means AC. What does AC means? Very well, something different.
Please.
So he should get AC 75 and 50 in all.
Please.
TTL also 200, 100.
No, total is 200, my lord. For minimum marks is 100, my lord. For general, it's 100. For reserved candidate category, my lord, it's 90. My lord, though he is secured 92, but he does not meet that threshold of 100 for general merit to be considered him under general category.
He doesn't get 50
Please,
and 100.
please, my lord.
That's right. Yes, Mr.
That is
Gupta.
not in dispute, my lord. He did not get 50%. He get lower marks.
Tell us one point why he should get an unreserved seat
Because
without securing 50 and 100 marks.
Because kindly see para 3 of this DOPT instruction.
Okay.
The basic question raised by the Department of Revenue is whether the SC/ST candidate who qualify the departmental examination with less than 60% in this case marks would be eligible for promotion against unreserved vacancies. This by the question referred to DOPT. Kindly see para 5. Unreserved vacancies are open for all category of persons, including SC, ST, OBCs. However, while making appointment promotion to an unreserved vacancy, no relaxation concession is permissible for any category of candidates. This department in OM 1st July 1998 provides that SC, ST, OBC candidate would be treated as unavailable for an unreserved vacancy if he has availed any relaxation concession, including that of age limit, experience, qualification, permitted number of chances in written examination, extended zone of consideration larger than what is provided for general category candidates, etc. The advice as given earlier and indicated in this para 4 above is in line with the instructions contained in so and so.
So what do you mean by larger than?
In this,
what is provided by general
in this instruction, DOPT has not considered the relaxation marks, passing examination with relaxation marks as relaxation for promotion. They have given other criteria which can be considered as relaxation.
We will read paragraph 5, fourth line. The department dated 1st July provides that SC/ST candidates would be treated as unavailable for unreserved vacancy if he has availed any relaxation concession, including that of age limit, experience, qualification, permitted number of chances in written examination, extended zone of consideration larger than what is provided for general category candidates, etc. So that means if it is beyond what is permissible to the general category, then you are getting all this relaxation, then it is unavailable.
If I get any of these relaxation, but I am not getting any of these relaxations.
But the intent is only this lower thresholds or on a relaxed standards. That's the intent.
My specific question was whether examination with the lower marks will be treated as relaxation or not. DOPT has not treated it as relaxation. It has given a list of other relaxations. This was specific question.
Okay. Where is impugned order? Which page is impugned order? 86.
Page 86 onward. 86 onwards, my lord. The conclusion given is at page 6 of the order. There are 6 last 5 lines. It was held therein that promotion of SC/ST candidate who were declared successful and qualified in ITO departmental examination of relaxed standard could not be allowed to compete with general candidates, as they could not have been promoted based on their own merit.
Yes.
Yes.
This is the 25th April 2016 is the impugned order?
Yes.
Please, my lord, page number 86, annexure D, my lord.
Yes.
My lord, may I request my lord to kindly turn to page number 91, my lord. The tribunal has considered the issue. My lord, my
Why
lord.
does the tribunal say therefore contention applicant already stands covered by the aforesaid judgment 868?
My lord, the
What does 868 say?
lord, 868 is this is a different issue.
Don't understand why don't
Please.
is disposed of. Ultimately, it doesn't go into the question which is required to be decided. What is your stage? What is your post which you are holding?
At present, I am ITO, but at that time I was inspector.
So you are inspector.
Yes, ma'am.
So this promotion is to the post of ITO or
ITO.
inspector?
Inspector to ITO, my lord.
Yes, Mr. Gupta.
Yes, ma'am.
So you are seeking promotion from inspector to income tax officer, ITO?
Yes, ma'am.
Where you got promotion in 2015 as ITO. But what would be did you get it on relaxed standards or not?
I got it on my own seniority, not on my own merit.
You got only on your own seniority,
On reserve point.
reserve seniority.
Yes, ma'am.
Okay.
Yes, ma'am.
To the post of ITO.
Yes, ma'am.
Okay. Now your seniority gets restored, or it will be back to the same old seniority of your IT. See, you got the promotion on accelerated basis because of the relaxed standards.
No, I got promotion in normal course.
Did you get your promotion on the basis when the junior got it?
No.
No.
I got when my promotion was due on reserve point as per seniority.
But relaxed standards.
No. Examination is one time to be passed for general with 50%, with the others with 45.
Okay.
I passed examination once, then I got promotion in my due course.
Oh, you got it in your due course.
Yes.
How were you promoted? You got it in due course.
Yes.
That was only a qualifying exam.
Yeah, only qualifying examination once in a whole service, not every year.
What is your case?
No, my lord, he has been promoted on the relaxed standards. My lord, instructions are also that he was promoted to the reserved post on relaxed conditions.
To the post of ITO?
Please.
On the relaxed standards?
Please.
Is it not a qualifying exam? Is it a qualifying exam? But qualifying exam on relaxed standards.
Please.
But according to him, he got promotion on his basis of his own seniority as an inspector in the reserve category.
Yes,
seniority among the reserved candidates.
Among the reserve candidates.
Please.
And no junior superseded him.
No.
He got in his own.
Junior superseded was a general merit.
Junior superseded was the general merit candidate.
Huh?
The junior superseded was the general merit candidate, not the reserved candidate.
Athava general merit candidate.
Please.
Difficult, Mr. Gupta. Just say this, the challenge in this petition is to an order dated 25th April 2016 in OA 1222 of 2013, whereby the OA filed by the petitioner has been disposed of by the tribunal by stating in paragraph 7 and 8 as under. The petition, though the OA was disposed of, the petition has been filed by the petitioner being agreed by the said order. The submission of Mr. Gupta is that the petitioner was appointed as a lower division clerk in the year 1995. He was promoted to the post of income tax inspector on 26/12/2005. The next promotion post is that of income tax officer. The recruitment rules for the post of income tax officer contemplates departmental examination, which was held in the year 2007. The petitioner passed with aggregate of 48.61 as the petitioner was granted the benefit of concession marks. Otherwise, a general candidate is required to pass the said examination with 50%. There is no dispute that the petitioner was promoted to the post of income tax officer on 28/7/2015. That's right?
Please.
28/7/2015. The submission of Mr. Gupta is that the petitioner, having been promoted as per his seniority, you are seeking seniority only? What are you seeking?
My lord, I am seeking that I should be promoted on my own merit. This passing
From
with
which date?
due date.
What is due date?
Due date is will be required to be calculated. It will be required to be calculated if I am giving benefit.
He states that the petitioner is required to be promoted as per his due date, which need to be calculated by the respondents, and his promotion to the post of ITO need to be advanced.
Yes, sir.
Need to be advanced
On my own merit.
Need to be advanced.
Yes,
on the other hand, learner counsel for the respondent would submit that the petitioner was in fact was promoted to the post of income tax officer as per his own seniority. That's right, in the grade of inspector. According to him, no junior belonging to the reserve category has superseded the petitioner. He do clarify that a person, an unreserved category person who was below the petitioner was promoted to the post of income tax officer.
Excuse me, Lord. The reserve category candidates who got 50% marks, they superseded me. Even my juniors were promoted.
Okay, very good.
Yes.
He submits this submission of the learner counsel for the respondent is contested by Mr. Gupta by stating it was those persons who were junior to the petitioner who have secured more than 50 marks, got the promotion on their own merit.
Yes.
On their own merit.
Yes.
With that as it may, the fact that the petitioner had secured 48.16% of marks in the departmental examination, comma, he has secured less than 50% marks, which is otherwise required for securing a promotion on own merit. Full stop. In that sense, the promotion was on the basis of relaxed standards. Even otherwise, it is stated as stated by the learned counsel for the respondent that the petitioner got promotion as per his seniority, being a reserved category candidate. Full stop. If that be so, comma, the submission of Mr. Gupta that the petitioner's promotion need to be advanced from a date to be calculated by the respondents cannot be acceded to. The reliance placed by Mr. Gupta on the advice given by the DOPNT dated 24/7/2007 has been seen, and it is suffice to state the said advice clarifies that to determine whether an SC/ST candidate in the zone of consideration can be promoted or not when there are no reserve posts, it should be seen, it is stated that it should be seen whether the candidate would have been promoted if he did not belong to SC/ST, SC or ST category. If yes, he should get promotion, otherwise not. Yeah, just cut that. Otherwise not. Suffice, full stop. We make it clear that the petitioner, having availed the relaxation in the standards, comma, he cannot be treated to have secured promotion on his own merit, promotion to the post of income tax officer on his own merit. Full stop. If that be so, comma, we agree with the conclusion drawn by the learned tribunal.
But my lord, this para 5 is not being considered. This para 5 is relevant, my lord.
We have said so also. Very well. One of the submission of Mr. Gupta is that the paragraph 5 of the DOPT advice must be read to mean where the relaxed standards have been given only in respect of age limit, comma, experience, comma, qualification, permitted number of chances in written examination, extended zone of consideration, larger than what is provided for general category candidates, etc. Only and nothing more. We are unable to agree with the submission made by Mr. Gupta for the reason that the word candidates is followed by the words etc, which encompasses a situation where a person has been given relaxation even in the standards of examination, standards of departmental exam, standards relating to departmental examination. In view of our conclusion drawn above, we do not, we are of the view that the tribunal
My lord, in this case, the reference made was direct on this issue. And on this issue, there is no direct answer by the DOPT. They have given only.
And we agree, we are suffice to state in paragraph 6 of the order, the tribunal in last 5 lines of the same has stated as under. 1, 2, 3, 4, fifth line, ma'am, from the bottom in para 6, which we reproduce. In view of our discussion above, we do not see any merit in the petition. Same is dismissed. Next. Here.
Thank you.
Just keep it in the file.
44 adjourn. Say number 45, government defeat.
What's IFA for the respondent?
State, my lord. State appeal, my lord. Lord, we are ready for the argument. Lordships may kindly fix a date.
Lords, the first thing is they had to give the paper books. That was the order. Secondly, 20 lakhs ought to have been deposited as directed by the Honorable Court.
No, you have not deposited that amount. You don't
Not
want to
yet.
deposit.
My lord, we have
Go for execution.
we have
my lord.
strictly communicated the department people also, my lord, that
Not the in the executing court, they produce this order copy and say there is a stay given by the Honorable High Court. Therefore, you shall not proceed is the submission made before the commercial court in the execution proceedings. They are little apprehensive to go further unless it is made clear by this Honorable Court that there is no stay insofar as further recovery is concerned. But there has been a blanket stay without any amount being deposited therein.
Yours the order.
my lord,
Kindly-
it is 1011 order, my lord. The work was valid for 13 lakhs. The award amount is
Ma'am, we will
59
see the
lakhs.
order, ma'am. Where is the order?
That 1011, my lord.
10th of?
10 November 2022, my lord. Initially, my lord,
Okay,
and subsequently, my lord, on
When you say argued contractual, the award is this, the arbitrator
subsequently 24/1/23 order also. my lord.
would further enter in that way of the matter pending consideration of stay of all proceedings. And where is the deposit of 20 lakhs?
They have not done.
It is
No,
not.
which order?
Your Lordship,
That is on 24, my lord, 24/1/23 order. The last paragraph. This court by order dated 10/11/22 was pleased to grant an interim relief. Having heard the learned counsel, we are of the considered opinion that equity shall be met if the appellant is permitted to deposit a sum of 20 lakhs before this court. The amount deposited shall be placed with FD.
thereafter they didn't deposit. Thinking that it is amenable for a contempt, I filed a contempt petition before the division bench of this honorable court. And the Honorable Chief Justice was to say that it's only a permission granted to deposit. Therefore, it cannot amount to a contempt, and also for the fact that the matter is pending before this division bench. So my contempt petition came to be dismissed. But I am now a contractor for the last 25 years, have not got a single pie from them. And works have been completed, possession has been given to them. No money is given to me so far.
On the ground that
How much is the liability?
59 lakhs, my lord. My lord, 3 times more, my lord. The value of the work is only 13 lakhs. And, my lord, the award amount is 59 lakhs. On this ground, my
But
lord.
the work was for 13 lakhs.
Yes, my lord. Our 34 petition was dismissed, my lord. My lords may kindly see the our 3 times more, my lord. On that ground, my lord, this court had initially granted interim order, my lord.
That is for the reason certain works were not covered in the initial tender. The site which was given to me did never belong to the government. It was in a different place. Therefore, the work which I started and employed my labor there will have to be taken into consideration, which was not part and parcel of the contract.
Is the award?
Your Lordship.
In page 40, my lord. And, my lord, they had not placed any documentary evidence also, my lord. That, my lord, the arbitrator has clearly given a finding on that.
Which page is the award?
It is on at page 40, my lord.
Commences at page 40.
Page 40, my lord. My humble request is, my lords, may kindly fix a date, we will argue the matter.
No, last time also we have said so. This is with an understanding. You said take
No, no, my lord,
instructions.
we have communicated the order, my lord, strictly to comply and make the deposit also, my lord.
The only thing is, what will they do? You don't deposit. And they have an award in their favor.
Can I pursue your lordship with the judgment of a Calcutta High Court, wherein 18 crores was the award amount, and there is an order that the entire amount has to be deposited, there cannot be any
Supreme Court
blanket.
is very clear on this.
Yes, my lords.
Yes. What is the date in the execution?
It has been posted to June, my lord.
How much?
No, amount in the execution is
No, no.
When is the execution?
June, my lord.
June, my lord.
Which date?
2nd June. Correct? I'm sorry, my lord, he doesn't remember it.
See, we can only once say, being a government, I don't think you should have any problem
Yes, ma'am.
in getting the money. But the only thing is the way they also, despite an order, they have not deposited.
For a moment, if my lords. May I, my lord? For a moment, if my lords may see page 55, my lord. The arbitrator has clearly given a finding, my lord, that in absence of documentary evidence, they have not produced anything, my lord, to
What did
conclusion,
they
my
produce?
lord, page 55, my lord.
What did they produce?
Market rate, my lord, as claimed by them.
Let's see a document which you have produced.
My humble request is, my lord, the date may be fixed. Aditya, I think he's already made
Where is he?
his argument. He's held up in other court, my lord. Because he's already started his argument in this matter, my lord, so I don't want to. But we have communicated the department, my lord, to make the deposit. The arbitrator has said, my lord, the market rate he claimed is more than the rates approved by the respondent department. The claimant has not submitted supporting documents in support of the market rates claimed to substantiate his claimed amount. This is the finding of the arbitrator. Lord, as such, my lord, the interim
Where
order
is
was,
that?
it is at page 55, my lord. Conclusion, para number 4, page 55.
No, the next paragraph,
It's in the
it's very clear.
conclusion part.
The claimant is entitled for new rates for the extended period of contract, especially when the extended period is nearly 5 years.
How can you say new rates?
But
Same rates would be there.
no. Price rise, for example, brick, cement, steel, labor, that all has been taken into consideration by the arbitrator. Your Lordship may kindly turn to page 57, conclusion. From the above clause 7A, the payment is required to be released within 30 days. Beyond 30 days, it is considered as delayed payment and the claimant is entitled for interest as per the Contract Act. Details of delayed period and claimant's eligibility for payment for the delayed period is considered at 15% per annum and the total amount due to the claimant on account of delay.
I think we will hear this.
Please, ma'am.
But an interim relief should be given to me.
What?
My lord, the 20 lakhs, I should get it at least. He has spent.
Order, how many times we'll repeat the order?
My lord, I failed in the contempt court, executing court there.
That we understand.
They're apprehensive.
That we understand as long as this award is there.
Yes.
It is executable.
Your Lordship may kindly, make it clear that I can continue with the execution petition. At least let them pay 20 lakhs in the execution petition. At least that much.
Which date?
In June it is there, my lord. In the execution petition against this, please let them pay 20 lakhs to me. He has to survive, my lord.
The very amount we have challenged.
Claimant entitled to rates. The department is required to collect the market rates along with the claimant to ensure reasonable rate is filed. What is this 30% of the market rates?
That is the enhanced rate because from it was, the contract was in the year 2008. But they took about 3 to 4 years to properly identify the location where I should build that hospital. It never belonged to the government and therefore it is relocated and I was asked to. Therefore, there is an increase in all the cost of the materials. And for nearly 2 to 3 years, the entire labor force and lab machinery,
These
concrete
new
mixing
rates are
machine,
without
everything was
any-
kept there.
New rates are without any basis, my lord.
So if that were to be so, they could have given me the rates which are applicable to where they have paid for other contractors. No evidence is placed by them on record. And much more than that, my lord, nobody has got examined on behalf of the respondent company. The government. No one is examined. So I would draw your Lordship's kind attention to Vidyadhar's case, where they file a written statement and they don't come forward for cross-examination. It can never be taken as true. So in such circumstances, whatever I have told, I have deposed before the court, well cross-examined by them.
Okay, we'll just set out for you.
My lord, your Lordships may
The
kindly
last
fix a
opportunity,
date,
ma'am,
please,
we
ma'am.
will not,
Please,
we
ma'am.
will not adjourn the matter now.
Please, ma'am.
He's right. He has
I
an
understand.
award not deposited,
Yes, ma'am.
nor even paid to him. There is a last opportunity on the request made by the counsel for the appellant. The appeal is listed on. Just give it in June 2nd or 3rd week.
Well, some interim relief, some.
We will hear it. I think this requires consideration.
Please.
No, in any event, I'll not be entitled to a minimum of 40 lakhs. Therefore, 20 lakhs would be very reasonable if your Lordship were to.
19-6.
Obliged.
Thank you.
Obliged.
46. Appeal number 46.
For the respondent.
There is the defendant appeal I have filed preferred by this appeal before this honorable court, your lordship.
What is the issue?
The issue is the contractual employment has been taken by me from the respondent for particular persons, and they have not worked at that particular time. It is the period of the COVID has been started at that point of time, your lordship.
How long it would take?
It will take a half an hour, your lordship.
Just say that re-notify on.
23-6.
Please.
Serial number 47, Rajesh Kumar, 47.
For the appellant. Yes, Mr. Rajesh.
Please, my lord. Respond.
This is the defendant's appeal, my lord. The defendant was a tenant, my lord, under a registered lease deed, and the defendant terminated the agreement and offered to terminate the agreement and even offered to return the premises back. The plaintiff received the email, but subsequently, my lord, the plaintiff filed a suit saying that there was a lock-in period for the lease, claiming that I have damaged portion of the premises and sought for rent in terms of arrears in rent, sought for a claim of damage to the premises. And plaintiff's claim, my lord, was allowed in entirety in excess to what they also claimed, whereas my counter claim, my lord, was completely rejected. So on that basis, I filed the appeal, my lord. How much time you would take? Around 45 minutes, my lord. Oh. My lord, reason is, my lord. Vishankar, you?
It's about
Another
15,
45.
no, 15 minutes. I'll just go through the.
So 1 hour in total.
He may, my friend, I'm not sure whether it'll take 45 minutes.
No. See, whenever a lawyer says 45, you take it double. Obviously. Yes, ma'am. Huh? You will not reduce your time. Yes, You may go up. Yes. That's right? Yes. We'll have it some. Let's not have it parted. Just say this.
May I move for a short adjournment? May I move for a short adjournment?
We will take it to June. We'll
No,
be
I
very
understand.
clear, Mr. Ravi Shankar, we can't have it in April.
We hardly have another 10 days.
Pardon?
We hardly have another 10, 12 working.
That's right, it's not possible also. We have kept those last week for quite a few. In fact, his matters are also. Yes. Just say re-notify.
May I move for first week of June?
We will give you. We'll give you.
Great.
Just show me.
Lord, I have served the synopsis to my learned friend long back, but the office wouldn't take the synopsis across the counter. May I just pass on?
We will pass an order.
Yes.
Just say Mr. Ravi Shankar, counsel for the respondent is permitted to file the written synopsis in the registry.
Great.
He has already served a copy thereof to the on Mr. Rajesh appearing for the appellant. June. Ninth June. 9th June. Grateful.
48, Vishwam Shekhar.
My lord, I appeal for the appellant, my lord.
Yes, Mr. Somshekhar.
The divergent views between the labor court and the learned single judge regarding VRS acceptance.
We'll have it some other day.
Well, in
We'll
fact,
have it some other day, Mr. Somshekhar.
Please, my lord, please, my lord.
We notify on.
Please, my lord.
Next.
23-6.
Obliged.
Much
Serial number
obliged.
49.
Please, my
Wait.
lord.
We ask the appellant.
My lords, and for the
My lord, the
respondent.
matter was admitted on the previous occasion, but the paper books are yet to be filed. My lords, because we refer
My
to the
lords,
conference.
my lords,
that would not be a correct submission, my lords. There was a stay that was granted in their favor, subject to payment of 65% of the decretal amount, the award amount, inclusive of interest. They have deposited the amount, and I have, my lords, withdrawn the amount subject to furnishing a bank guarantee. On that date itself, I expressed to the learned judge that, my lords, there's severe urgency in the matter by virtue of me being a cash-strapped contractor. That is where I stand. I will leave it to my lords that I'm only expressing urgency in the matter, my lords, because there is an active bank guarantee and I'm incurring 14 lakhs expenses as bank guarantee charges. Is my request is, my lords, if they want to file a paper book, I will not come in the way that would assist the court, but my lords, a short date, and my lords may kindly.
The shortest we can give you is 2nd of June.
2nd of June, my lords.
First day of opening, I suppose.
My lords, any date. My lords, I saw the matters being re-notified, my lords. After 6th June, I will leave it to you.
After 6th June?
Yes, please. I would leave it to the court. I saw my lords was expressing a heavy board in the beginning of the week.
6th June. You come on 10th June.
I'm grateful, my lords. My lords, subject to them filing the paper book.
Let's say that re-notify on 10th June. It is made clear that the counsel for the appellant states that the paper book shall be positively be filed in the registry at least on or before 5th of June 2025. It is made clear even if the paper books are not filed, the matter shall be heard. Okay.
I'm ever so grateful.
Past door matters. 16, serial number 16. Kirti.
For the appellant.
Yes. How much time?
Half an hour, one.
Senior counsel also would take that much time.
I have it in June. Okay. Just re-notify on.
Your Lordship, if I may request before vacation another date, Your Lordship.
We will take it in June.
As soon as it reopens.
That's right. 13th June.
13th?
13th June.
Please, sir. Interim order may kindly be extended. No?
Interim order if I need to continue.
That's okay.
21, serial number 21.
I'm appearing for the appellant, my lords. My lords, some time may be granted, my lords. There are multiple matters clashing today and my senior is on his legs.
Final bill and escalation bill is not yet paid, madam. They deposited 25% before the lower court and we filed a withdrawal petition also.
We have heard you on this.
It's been heard.
From the other side, we heard.
My lords, there is another matter, my lords. My senior is on his legs. That's
Last year we heard from the appellant, madam.
Multiple. There's matters clashing, my lords. It may be had.
2014, we have
filed an application for withdrawal.
That is the application.
So we'll allow that.
My lords. My lords, it may be had. My lords, the arguments were partly heard, my lords. It may be had or not.
Final bill and escalation bill comes to more than that deposited amount. They deposit 25%, my lord, before the lower court.
Did we hear this matter? When did we hear this matter?
Last.
Just say at the request of counsel for the appellant for an adjournment on the ground that the arguing counsel is held up in another court. Adjourn to 17th June.
The meantime, they were permitted to deposit in the 25% they deposit and not full amount, my lord.
That's it. Maybe heard on 17th.
This is government.
Yes, yes, my lord.
It's all right then, Mr.
No, escalation and price final bill comes to 2 crores and odd without interest, my lord.
Mr. Reddy, I think government, you should not have anything. Once you succeed, everything will
That
follow.
were completed the 2014, my lord.
I know you're right.
See, they are enjoying that rail over bridge. 4 crores work. No, kindly bear with me, my lord. 4 crores work becomes 9 crores.
Okay. We'll just
And final bill is not settled, escalation bill is not.
That's right. We recollect. 17. You said 17. Just 17, you no further adjournment. No further adjournment shall be granted. Next.
32,
Grateful, my lords.
till number 32, Sri Vinay.
Yes, what are instructions?
My lord, senior is held up in another court.
Why did we pass over? Oh, this is the trademark.
Yes, sir. May I just pass one photo, my lord? Just for my lord.
Just you can take that.
Just 1 minute, my lord, nothing else. My lords may see the logo on the gentleman's t-shirt. And if my lords may now turn the next page over. And my lords may see when I have clicked it. 5th April 2025, 2 days ago.
Who is this gentleman?
That I'm not aware, on the way I had seen it.
We don't know. No.
I'm just saying let them not.
This is not an evidence.
No, I'm just saying let them not use the mark.
We don't know.
Where?
We don't know if the mark is being used or not. No, not like this. This is not an evidence.
Since my learned friend said my lodge is not very well.
He will not look into this evidence.
Where?
The matter may be taken up tomorrow.
But what are your instructions? You don't have any instructions.
No, my lords, because senior was.
The counsel for the appellant is held to be busy in another court. Re-notify this. Which number?
32 months.
30 adjourned to. The learner counsel for the appellant shall take instructions. This is 30.
32, ma'am. 32 months.
Yeah. As adjourned to, he shall take instructions as to whether the appellant is using the trademark. The impugned trademark, okay, on the next date of hearing.
Tomorrow will be.
You'll come tomorrow? Day after tomorrow.
9/4.
Day after.
35, Sri K.V. Narasimhan.
Here for you.
Yes, which number?
35, serial number 35.
How long you are taking?
That the matter pertains to the doctrine of pleasure being invoked to remove the government pleaders.
Why? What under what provision?
It is stated, my lord, that under Rule 5(6) of the Karnataka Law Officers Appointment and Condition of Service Rules 1977.
So, which judgment you are relying upon?
My lord, I have placed on record, my lord, I have filed my compilation.
Srilekha Vidyarthi?
Yes.
Huh?
Yes, please. That is, my lord, followed by the learned single judge of this honorable. BP Singla, my lord.
But what does the learned single judge holds?
Learned single judge, my lord, gives me a qualified protection. He says that I do not have a locus standi to challenge my removal. In the meantime, my lord, I would have challenged the appointment of somebody else who was, my lord, appointed without following the rules, my lord. Now that is set aside. Until and unless the regular appointment is done, my continuation, my lord, is provided for. Now,
so you are continuing today?
Now what happened, unfortunately, there is, my lord, in the interregnum, my lord, a fresh appointment was made in relation to the very same person. I challenged it before the learned single judge. Again, my lord, that has been quashed. The fresh appointment is quashed. But my removal is again upheld, my lord, by the learned single judge. Now, because of the fact that in this matter, my lord, the view has been taken that I would not get any locus standi to challenge my removal, because it says that the pleasure that would be exercised by the state is absolute and I cannot.
What is the ground for challenge?
Twofold, my lord. I was appointed, my lord, in the year 2022. 3 years, my lord, was the term that was stipulated, or my lord, at the pleasure of the state. 3 years, my lord, had not yet lapsed. 1/1/2024, my lord, lock, stock and barrel, my lord, concerning a large number of government pleaders, a single notification was issued. We were all removed and somebody else, my lord, were appointed. The rule specifically requires that the notification will have to be published, calling in for the applications. Applications will have to be processed. The remarks of the district judge and the district collector will have to be taken note of. That shall be forwarded to the state. The state shall make an appointment.
This is where appointments were?
My lord, 2 taluks, my lord, one in Chandraipatna and another in Holenarsipura, both in Hassan district. So we brought this to the notice of the learned single judge that the rules have not been followed. The learned single judge, my lord, is with me as on that regard and holds that.
Today they are practicing now.
I'm practicing, my lord, in a sense that 1/6/2022 is when one of the appellant, my lord, was appointed. Otherwise, my lord, that appeal, my lord, would become infructuous because of the flow of efflux of time.
Doesn't make any difference. You should be concerned before the appellant must be concerned for themselves.
Now, my difficulty is, my lord, now whenever I challenge, my lord, the appointment of somebody else, notwithstanding the fact that the rules are not followed, this judgment comes in my way, and I'm told that you do not have the locus standi to challenge your removal.
Right.
That is how I have lost, my lord, one petition, and the order has been released only yesterday, and I need to file another writ appeal challenging that.
So there was another.
Now, in the interim, my lord, what happened is, pursuant to the impugned order, my lord, the government, my lord, called in a fresh notification. They did not take sufficient publication, and it was done, my lord, in a lackadaisical manner. We brought to the notice of the learned single judge again. He found favor with us, and he said that procedure is not followed. But having said so, again, my lord, in a number of situations, we are faced with the condition where these judgments are being relied upon, and I said, you don't have the locus standi to challenge it. Now, even though illegality is brought to the notice of the court, my lord, my continuation is not being ordered for. And this is staring at me. That
What
is
would be the effect of the new order passed by the learned single judge?
No, my lord, I need to challenge it, my lord, only.
This appeal.
Now, this, my lord, this nevertheless, my lord, would survive, because the learned single judge has taken a view that if this is being urged in a writ appeal, even that can also be urged in the writ appeal. So I need to file another appeal and get it connected with this appeal, and then.
So you file that. You notify all. This is only you can only rely to the extent of the grounds of challenge.
Well, ultimately, my lord, I have got 3 to 4 months. If they do not disturb me for 3 to 4 months, my lord, my term would be over.
But you are continuing today.
I am indeed continuing because
because of the stay.
No, the impugned order, my lord, protects me.
Then you will continue. Then what is the problem?
No, the notification, my lord, is again ordered to be called for. The learned single judge in the other matter.
How long that takes?
1 month, my lord, is the time that has been fixed by the learned.
Do you think they will complete the process in 1 month?
My lord, if they do it, my lord, they will again, my lord, violate the rules because they can't do it. They need to call for paper publication and notification, etc.
Re-notify.
It will be in first week of June, please.
First week
of June.
Everyone is working. We are clogging it.
And the reason
Same
is this,
thing
my
will
lord,
happen.
the appellant, my lord, will complete his tenure on 1/6/2022 in the connected appeal. I don't want my lord to ultimately.
You want May? We'll give you. Have it on June. They'll give it June. Let's see that. Not just give any date. 13th June.
Great.
Okay. Next, yes, that matter is there. No?
36, yes, Naik.
Which one, ma'am?
36, sir.
These were yours for 35. No?
See number 36.
To appear none for the parties adjourned to.
9/7. Till number 37, she 14%.
You are ready for arguments?
Please, my lords.
You are for 3?
Respondent number 3, private respondent.
What is the position in Panipat? What is the position in Panipat?
It's been adjourned to July, my lords, I'm told.
Adjourned to July. Did he appear, Mr. Chadda, there?
Yes, my lord.
You are appearing? Oh, you are appearing?
He has gone only once, my lords, and he is taken.
This judgment was passed, CAV order was passed. After that, twice I have visited there.
Okay.
On the
When,
last
when was the last date? In Panipat?
Third January.
3rd January, my lord.
Oh, 3rd January.
Yes. My lord, I have a humble submission to make. I just want to place on record this one judgment, Anant Kumar Mohta and couple of them.
De dijiye.
So,
give it.
My lord, first to apprise this court that the filing of the charge sheet will not come in the way of granting a stay order.
Pardon? You argue your whole petition appeal. Argue it. We'll decide the whole appeal.
Decide the whole appeal on.
You will argue on the appeal, na? We'll leave that question open. We will hear him on that maintainability aspect also. And we will decide it.
Okay. My lord, for that I will have to place on record a memo of citation, my lord.
Give.
My lords, my one submission, my lords.
Yes.
If I'm allowed to argue on maintainability first, my lords, then we can go out on the merits.
Okay, very well. Maintainability.
Because the office has rightly raised an objection.
We'll argue on maintainability, what is being contended, so that he can also hear it now, because he was not there when we left that question. We should notice keeping the maintainability open. So you will argue maintainability so that he can also reply. Okay?
Okay, my lord. To my lord,
Yes, tell us.
Yeah, my lord, at the very outset, so I would just advert the attention of my lord toward the earlier judgment which I have cited. That is Shri Lakshman, son of Shri Jayanappa.
We will come to that. Their argument, maintainability issue raised by the registry is, since it is a petition which incorporates or a petition filed under 482, under section 4 of the High Court Act, it must, the division bench jurisdiction is taken away.
Please.
That's the point.
And the judgment relied by him on the previous date, my lords.
What is that?
That is Kim Wansu was a state of Uttar Pradesh, my lords.
You have got this
SEC.
judgment. 1 minute. You got this judgment he is relying upon?
Yeah, my lord, I submitted this judgment itself to my lords.
Okay.
This judgment I have already submitted, where the Honorable Supreme Court has clearly stated that FIR or charge sheet can be quashed either under section 482 of the CRPC or under article 226 of the Constitution.
Okay.
So it is a long-standing position of the Supreme Court since state of Haryana versus Bhajan Lal, where they are given 7 illustrative cases in which the Honorable Supreme Court may choose to exercise its powers either under section 482 CRPC or under article 226 of the Constitution of India. Now, in the given situation, the district has raised an objection that the learned single judge exercise the power under section 482. And I had clearly brought it to the notice of this court that section 482 is a territorial power which is applicable only to subordinate courts. It cannot be extended beyond the territorial jurisdiction of any high court. If any power is to be exercised beyond the territorial jurisdiction, it has to be necessarily exercised under Article 226(2) of the Constitution itself. It cannot be exercised within section 482. And in this regard, I just want to read
Okay, so
One
you say
para from this
482 only confines to the litigation within the state.
within the state, my lord. And this is state of Punjab, the Dwinder Pal Singh Bhullar. It is Supreme Court judgment of 2011, in which the Honorable Supreme Court has compared and contrasted Section 482 vis-a-vis Article 226. That what is the ambit and scope of these two section and articles?
Just
they have to be
take it.
compared and contrasted.
Take it, please.
Copy दीजिए. Copy दीजिए.
Copy I am not having.
You have to get the copy now if you are relying on the previous date also. I told you, you have to give it.
But here in this judgment, page number 18 of this judgment. Page number 19, para 40. So, my lord, I would like to read these two paras, rather these three paras. But I will first begin with para 2 on page number 19.
To which paras you will be relying upon? To
last two paras of the para 40. Last two paras of the section 40 on page number.
So you are
19.
relying upon only para 40.
Yeah, para 40. So these two paras, I would just.
Yes, read it.
Read it. Application under section 482 Code of the Criminal Procedure lies before the High Court against an order passed by the court subordinate to it in a pending case bar proceedings. Generally, such powers are used for quashing criminal proceedings in appropriate cases. Such an application does not lie to initiate criminal proceedings or set the criminal law in motion. Inherent jurisdiction can be exercised if the order of the subordinate court results in the abuse of the process of the court and are calls for interference to secure the ends of justice. The use of the word process implies that the proceedings are pending before the subordinate court. Well, again and again, the use of this expression subordinate court. When reference is made to the phrase to secure the ends of justice, it is in fact in relation to the order passed by the subordinate court, and it cannot be understood in a general connotation of the phrase. More so, while entertaining such application, the proceeding should be pending in the subordinate court. In case it attained finality, the inherent powers cannot be exercised. Party aggrieved may approach the appellate bar revisional forum. Inherent jurisdiction can be exercised if injustice done to a party. Example, a clear mandatory provision of the law is overlooked, or where different accused in the same case are being treated differently by the subordinate court. An inherent power is not an omnibus for opening a Pandora box, that too for issues that are foreign to the main context. The invoking of the power has to be for a purpose that is connected to a proceeding and not for sprouting an altogether new issue. Now, my lord, now here he is contrasting it with the power under Article 226. A power cannot exceed its own authority beyond its own creation. It is not that a person is remediless. On the contrary, the constitutional remedy of writs are available. Here, the High Court enjoys wide power of prerogative writs as compared to that under Section 482 Code of the Criminal Procedure. To secure the corpus of an individual, remedy by way of habeas corpus is available. For that, the High Court should not resort to inherent power under Section 482 Code of the Criminal Procedure, as the legislature has conferred separate powers for the same. Needless to mention that Section 97 Code of the Criminal Procedure empowers the magistrate to order the such a person wrongfully confined. It is something that the same court exercising authority can, in relation to the same subject matter, invoke its writ jurisdiction as well. So, my lord, here it's clearly stated that the High Court enjoys wide power of prerogative writs as compared to that under Section 482 Code of the Criminal Procedure, and clearly stated in the preceding para that Section 482 applies only and only to the subordinate courts. And then I want to immediately go to the preceding para's first line. To inhere means that it forms a necessary part and belongs as an attribute in the nature of things. The High Court under Section 482 Code of Criminal Procedure is crowned with the statutory power to exercise control over the administration of justice in criminal proceedings within its territorial jurisdiction.
Where are you reading?
The High Court under Section 482 Code of Criminal Procedure is crowned with the statutory power to exercise control over the administration of justice in criminal proceedings within its territorial jurisdiction. My lord, this is page number 18. Page number 18. This second last para on page 18. My lord, last para on page 18.
You must read in serial term. Come from 40.
from the beginning
Read,
itself.
obviously, read from 40. We have to read in context.
Okay, full para.
Obviously.
Okay. It is evident from the above that inherent powers can be exercised only to prevent the abuse of process of the court and to secure the ends of justice. However, powers can be used provided there is no prohibition for passing such an order under the provision of the Code of Criminal Procedure, and there is no provision under which the party can seek redressal of its grievance. Under the garb of exercising inherent power, the criminal code cannot review its judgment. Such powers are analogous to the provision of section 151 Code of Civil Procedure and can be exercised only to do real and substantial justice. The rule of inherent powers has its source in the maxim quod liquid aliqui considere videtur id sino quo ipsa s upon potest, which means that when the law gives anything to anyone, it gives also all those things without which the thing itself could not exist. The order cannot be passed by bypassing the procedure prescribed by law. The court, in exercise its powers under section 482 Code of Criminal Procedure, cannot direct a particular agency to investigate the matter or to investigate the case from a particular angle by a procedure not prescribed in Code of Criminal Procedure. Such powers should be exercised very sparingly to prevent abuse of process in any court. Court must be careful to see that its decision in exercise of this power is based on sound principle. To inhere means that it forms a necessary part and belongs as an attribute in the nature of things. The High Court under section 482 Code of Criminal Procedure is crowned with a statutory power to exercise control over the administration of justice in criminal proceedings within its territorial jurisdiction. Only within its territorial jurisdiction. This is to ensure that proceedings undertaken under the Code of Criminal Procedure are executed to secure the ends of justice. For this, the legislature has empowered the High Court with an inherent authority which is repository under the statute. The legislature therefore clearly intended the exercise of such power in the High Court to control proceedings initiated under the Code of Criminal Procedure. Conferment of such inherent power might be necessary to prevent the miscarriage of justice and to prevent any form of injustice. However, it is to be understood that it is neither divine nor limitless. It is not to generate unnecessary indulgence. The power is to protect the system of justice from being polluted during the administration of justice under the code. The High Court can intervene where it finds the abuse of the process of any court, which means that wherever an attempt to secure something by abusing the process is located, the same can be rectified by invoking such power. There has to be a nexus and a direct correlation to any existing proceeding, not foreclosed by any other form under the code to the subject matter for which such power is to be exercised. Application under section 482 Code of Criminal Procedure lies before the High Court against an order passed by the court subordinate to it in a pending case proceeding. Well, it's 7 times subordinate court expression has been used in this para. Generally, such powers are used for quashing criminal proceedings in appropriate cases. Such an application does not lie to initiate criminal proceedings or set the criminal law in motion. Inherent jurisdiction can be exercised if the order of the subordinate court results in the abuse of the process of the court and or calls for intervention to secure the ends of justice. The use of word process implies that the proceedings are pending before the subordinate court. When reference is made to the phrase to secure the ends of justice, it is in fact in relation to the order passed by the subordinate court, and it cannot be understood in the general connotation of the phrase. More so, while entering such application, the proceedings should be pending in the subordinate court. In case it attained finality, the inherent powers cannot be exercised. Party agreed may approach the appellate regional forum. Inherent jurisdiction can be exercised if the injustice done to a party, example, a clear mandatory provision in the law, is overlooked or where a different accused in the same case are being treated differently with a subordinate court. An inherent power is not an omnibus for opening a Pandora box, that too for issues that are foreign to the main context. The invoking of the power has to be for the purpose that is connected to a proceeding and not for sprouting an altogether new issue.
Which judgment others?
So, my lord, this is what the law. And what Honorable Supreme Court has stated in this judgment, similar observations have been made by High Court of Kerala Division Bench in Krishna Kumar Menon versus Neotrix. So, my lord, just kindly I will advert the attention of the court towards
which page?
1 minute. Page number 55, my lord.
Yes.
Page number 55, para 6. The question to be considered in this case is not the power of the High Court under Article 226, but jurisdiction under Section 482 CRPC. Section 482 CRPC reads as follows: saving of the inherent powers of High Court. Nothing in this court shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise to secure the ends of justice. For the purpose of Criminal Procedure Code, High Court is defined under Section 2E of the CRPC as follows. High Court means in relation to any state, the High Court for that state. In relation to a union territory to which the jurisdiction of the High Court for a state has been extended by law, that High Court. In relation to any union territory, the highest court or the criminal appeal for that territory other than the Supreme Court of India. Therefore, High Court mentioned in Section 482 of the CRPC shows only its relation to the state. As under Section 482 CRPC, High Court can quash only complaints filed in the state. This court's powers, control and supervision, both judicial and administrative, are limited to courts in Kerala. For this proposition, we get support from the decision of this court in Chelappan versus Chandulal and Srithara Kamath versus Jwala Gupta. Article 366(14) of the Constitution of India defined High Court as follows. High Court means any court which is deemed for the purpose of this Constitution to be a High Court for any state.
Come to the next para.
Here, territorial jurisdiction, the High Court establishes clear a pending matter in a court under the jurisdiction of another High Court cannot be quashed by the Kerala High Court by using inherent powers provided under Section 482 CRPC. Similar is the power under Section 227 of the Constitution of India. Article 227(1) of the Constitution of India reads as follows. Every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. Matter may be different. Now, my lord, now he is telling matter may be different if the petition under Article 226 is concerned, where part of the cause of action arose in the state where the High Court is having jurisdiction. The jurisdiction of the High Court under Article 226 and 227 are separate and independent. A similar provision as contained in Article 2262 is absent in Section 482 or Article 227. Article 2262 reads as follows. The power conferred by Clause 1 to issue directions, order the writs to any government authority or person may also be exercised by the High Court exercising jurisdiction in relation to the territory within which the cause of action wholly or in part arises for the exercise of such power, notwithstanding the seat of such government or authority or the residence of such person is not within those territories. The above clause was inserted by the Constitution 15th Amendment Act 1978. By insertion of this clause, if whole or part of the cause of the action arose in a state, High Court of that state will get the jurisdiction. The position is well explained by the Supreme Court in Ireland Natural Gas Commission, Mr. Utpal Kumar Basu. So, my lord, it is abundantly clear that under Section 482, the power cannot be exercised beyond the subordinate court or the territorial limits of the court. The power can be exercised only under Article 226 of the Constitution. And this point has been clarified by Supreme Court in a number of the cases. Only one I will read, my lord. My lord may permit me. Jendran Naveen Chandra Majithia, my lord, which is the most authoritative case which is cited in this case. So I will just read from which page. One moment, my lord. My lord, page number 79. Para number 33 and 34. When the Constitution was framed, Article 226 as it originally stood therein provided that every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories, directions, order the writs. Some of the decisions rendered by different High Court during the earlier years of the post-Constitution period have given a wider perspective regarding the jurisdiction of the High Court and pointed out that a High Court can exercise powers under Article 226 even in respect of tribunals or authorities situated outside the territorial limits of its jurisdiction. If tribunals or authorities situated outside the territorial limits of its jurisdiction, if such tribunals or authorities exercise powers in such a manner as to affect the fundamental rights of the person residing or carrying on business within the jurisdiction of such a High Court. So, my lord, now I am moving to the next para. But a constitution bench of this court has held in Election Commission of India versus Saka Venkat Subba Rao. Thus, the power of the High Court to issue writs under Article 226 of the Constitution is subject to twofold limitation, that such writs cannot run beyond the territories subject to its jurisdiction, and the person and authority to whom the High Court is in power to issue writs must be amenable to the jurisdiction of the High Court either by residence or location within the territory subject to its jurisdiction. It was a set decision of the Constitution bench which necessitated the Parliament to bring the 15th Amendment to the Constitution, by which clause 1A was added by Article 226. That clause was subsequently renumbered as clause 2 by the Constitution 42nd Amendment. Now, clause 2 of the Article 226 reads thus: the power conferred by clause 1 to issue directions or the writs to any government authority or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power, notwithstanding the seat of such government or authority or the resident of such person is not within those territories. The object of the amendment by inserting clause 2 in article was to supersede the decision of the Supreme Court and Election Commission of the Saka Venkat Subba Rao Supra and to restore the view held by the High Court in the decision cited above. So the power conferred on the High Court under Article 226 could as well be exercised by any High Court exercising jurisdiction in relation to the territory within which the cause of action wholly and in part arises, and it no matter that the seat of the authority concerned is outside the territorial limit of the jurisdiction of that High Court. The amendment is thus aimed at widening the width of the areas of reaching the writs issued by the different High Court. This was the entire background of the history in which Article 226(2) was inserted by conferring the High Courts with the power to exercise extraterritorial power. Now, here the question which is being raised is within the ambit and scope of Ramkrishna Fauji versus State of Haryana. Now, they are stating what is being dealt with is the letters patent of the Punjab and Lahore High Court, which are applicable to the Punjab High Court. So, in those letters patent, it is very clearly written that the criminal jurisdiction is excluded. If we read those letters patent, it becomes very obvious that yes, the criminal jurisdiction is excluded in that. But when we come to our High Court of Karnataka, Section 4, what we find is that it is a substantial reproduction of the Article 136 of the Constitution. If we use that phrase which has been used, judgment, decree, order, or sentence, the expression sentence has been very expressly used, my lord. The sentence connotes that any punishment, any forfeiture of property, any capital punishment, or anything of that sort, connoting that the criminal jurisdiction inherently contained in it. So, that judgment in its two parts. Part 1 of the judgment deals that where the power has not been taken away from the High Court expressly by the legislature, the High Court will continue to exercise its writ jurisdiction in exercise of the criminal powers. And the latter part of that, the second part of that judgment deals with the comparison of the letters patent of the Punjab and Haryana High Court with those of the Delhi, Gujarat, and Andhra Pradesh. After that discussion, the Honorable Supreme Court has concluded that since in the bracketed portion of these High Court letters patent, this express prohibition regarding the criminal jurisdiction is contained, therefore these courts are prohibited from exercising the criminal jurisdiction. But that prohibition is not contained in the letters patent of Karnataka or Kerala or Chhattisgarh or Madhya Pradesh, because the legislature is having the power to confer that jurisdiction on the High Court. So that aspect has also been dealt with in Ramkrishna Fauji.
Show us.
Okay. So, my lord, it is on page 199.
Petition is filed under 226 Constitution related to section 400. तो ये क्या है ना जब उसे यूज करते थे वर्ड ठीक है उसे जो इसको क्या है ना कुछ लिखा था साहब party is rightly 26 to 27
केरला कर्नाटक के जजमेंट इसी तरीके से जबरदस्त
Yes.
So my lord, it is on page number 199. So from here, the discussion has been made.
Yes.
And we do further ordain. So my lord, this is the class 10 of the letters patent of the Punjab and Lahore High Court, which has been brought out here. On page 199.
Lahore has, Punjab has LP, letter patents.
Pardon, my lord?
Punjab has letter patents.
My lord, this.
Now tell us one thing. Otherwise, your jurisdiction lies with before the Punjab Haryana High Court. Otherwise,
My lord, the entire cause of action has arisen within the territorial jurisdiction of this court. So by virtue of the Article 226(2), only this court is having the jurisdiction. At no point of time, any cause of action has arisen in Panipat. And the other day I explained to this court that the judgment of the Rupali Devi does not apply in the given case because the complainant has sent a complaint through post from here itself, and her statement has been recorded under 164 CRPC before a magistrate, where she is clearly admitting that she continues to stay in the bank quarter. There was absolutely no occasion of shifting any time to the parental home. So the advantage of that judgment will not be available to her. So all along she has been staying in Bangalore on the day when this FIR was lodged. And in addition, this FIR is hit by TT Antony with the state of Kerala, which clearly states that only the earliest and the first information in regard to the commission of a cognizant offense will satisfy the requirement of section 124. Therefore, there cannot be a second FIR and no fresh investigation on receipt of every subsequent information in relation to the same cognizant offense or the same occurrence or incident. A police officer in charge is required not only to investigate the same cognizable offense reported, but all other connected offenses. So, that is very, and as regard the aspect of investigation, in TT Antony itself, the Honorable Supreme Court has very clearly stated the sweeping power of the investigation does not warrant subjecting a citizen each time to the fresh investigation. The sweeping power of investigation does not warrant subjecting a citizen each time to fresh investigation in respect of the same incident.
Oh, anything else? Unko sune, then we can hear them, na?
Okay.
Yeah. What is your case on maintainability?
Maintainability, I am relying on 3 judgments. One, as my friend has told, Ramkishan Fauji versus State of Haryana, my lord.
What is the proposition you are advised?
My submission would be that, my lords, not maintainable. If the relief sought is in nature of criminal jurisdiction, my lords, inter-court appeals are not maintainable, my lords. That is what was held in these 2 judgments.
His argument is 226 can be in court for quashing of FIR.
That has been answered here, my lords. Here also it's the same. 226. If it is for civil in nature, I'll read the relevant paragraphs, my lords.
You have that Kim Mansu also.
Yes, please, my lords. There also the learned single judge had passed the order of Allahabad High Court, which was challenged before the Supreme Court, my lords, not before the division bench of Allahabad High Court. There also they sought for the quashing of the FIR, which was dismissed by the learned single judge of Allahabad High Court. It came to be challenged before the Supreme Court. So he has relied on this judgment on the basis of the facts, not on the maintainability aspect.
Let's see, come to that judgment which you are relying upon.
Please, my lords.
This is a latest judgment. This is also
2017, my lords. Thereafter, my lords, based on this judgment, a similar case of facts, my lords, the Guwahati High Court, the division bench of Guwahati High Court has decided on the very aspect, my lords. Once I'll go through the Fauji judgment and then rely on that judgment. That is at page number 2, my lords, very beginning. The conception of criminal jurisdiction as used in clause 10 of letters patent is not to be construed in a narrow sense, it encompasses in its governor inception and consequence. It is field in respect of which jurisdiction is exercised is irrelevant. Contention that solely because is a writ petition is filed to quash an investigation, it would have room for intra-court appeal, and if a petition is filed under inherent jurisdiction under section 482 of CRPC, there would be no space for an intra-court appeal, would create an anomalous, unacceptable and inconceivable situation. The provision contained in letters patent does not allow the permit such an interpretation. When courts are required to consider a bar or non-permissibility, courts have to appreciate same in true letters and spirit. It confers jurisdiction as regards subject to controversy or nature of proceedings, and that subject is exercise of jurisdiction in criminal matters. It has nothing to do whether order has been passed in exercise of extraordinary jurisdiction under Article 226 of Constitution or inherent jurisdiction under Section 482 of CRPC. In case at hand, writ petition was filed under Article 226 of Constitution for quashing of recommendation of Lokayukta. The said recommendation would have led to launching of criminal prosecution. And as factual matrix reveals, FIR was registered and criminal investigation was initiated. The single judge analyzed the report and ultimate recommendation of statutory authority, and though it seemed to quash the same, and after quashing the same, as he found that FIR had been registered, he annulled it, treating the same as natural consequence. Thus, effort of writ petition was to avoid a criminal investigation, and a final order of writ court is quashment of registration of FIR and subsequent investigation. In such a situation, to hold that a single judge in exercise of jurisdiction under Article 226 of Constitution has passed an order in civil proceedings, as order was challenged, was that of quashing judicial authority, that is Lokayukta, would be conceptually fallacious. It is because that matters is the nature of proceedings, and that is litmus test. Intra-court appeal against such an order is not maintainable. And it has been the paragraph number 58 at page number 19, my lords. When the court passed this judgment, my lords, it has relied on few judgments. At paragraph number 58, page number 19, the full bench of High Court of Delhi in CS Agarwal versus State and others was dealing with the situation wherein a writ petition was filed before the High Court under Article 226 of the Constitution of India, read with Section 482 of CRPC, seeking for appropriate writ or for quashing of FIR. As a writ petition was dismissed by the learned single judge, an intra-court appeal was preferred. A preliminary objection was taken by the respondent as regard the maintainability of the LPA, contending that the judgment of the learned single judge was passed in exercise of criminal jurisdiction, and a letter patent appeal against such an order is barred by clause 10 and clause 18 of the letters patent constituting the High Court of Jurisdiction at Lahore, which is applicable to the judicator of High Court of Delhi. The full bench analyzed clause 10 of the letters patent and took note of what has been prohibited for the entertaining an intra-court appeal. A full bench analyzing various decisions opined thus: proceedings under Article 226 of the Constitution would be treated as original civil proceedings only when it concerns civil rights. A forfeit of, if it concerns a criminal matters, then such proceedings would be original criminal proceedings. Letters patent would lie when the single judge decides the writ petition in proceeding concerning civil rights. On the other hand, if these proceedings are concerned with rights in criminal law domain, then it can be said that the single judge was exercising his criminal jurisdiction while dealing with such a petition filed under Article 226 of the Constitution. After so stating, the full bench referred to the Constitution bench deciding in Ishwarilal Bhagwan Das and distinguished the full bench a decision in Andhra High Court in Gangaram Kandaram and noted the decision of the division bench of Gujarat High Court in Sanjeev Rajendra Bhai Bhatt and came to hold as follows. The test thus is whether criminal proceedings are pending or not, and the petition under Article 226 of Constitution is preferred concerning those criminal proceedings which would result in conviction and order of sentence. When viewed from this angle, it is clear that if the FIR is not quashed, it may lead to filing of challan by the investigation agency, framing of charges, and can result in conviction or order of sentence. Writ of this nature filed under Article 226 of the Constitution, seeking quashing of such an FIR would therefore be criminal proceedings, and while dealing with such proceeding, High Court exercises its criminal jurisdiction. Then later, my lords, paragraph number 65. That is at page number 22, my lords. In the case at hand, the writ petition was filed under Article 226 of the Constitution for quashing the recommendation of the Lokayukta. The said recommendation would have led to launching of criminal prosecution, and as the factual matrix reveals, FIR was registered and criminal investigation was initiated. The learned single judge analyzed the report and ultimate recommendation of the statutory authority and thought it seemly to quash the same, and after quashing the same, he found that FIR has been registered. He annulled the treating the same as natural consequence. Thus, the effort of writ petition was to avoid the criminal investigation, and final order of writ court is quashment of the registration of FIR and the subsequent investigation. In such situation, to hold the learned single judge in exercise of jurisdiction under Article 226 of the Constitution has passed an order in a civil proceedings, as the order was the challenge was of the quasi-judicial authority, that is the Lokayukta, would be conceptually fallacious. It is because what matter is the nature of proceedings, and that is the litmus test. In view of the aforesaid prismatic reasoning, the irresistible conclusion is that the latter patent appeal was not maintainable before the division bench, and consequently the order passed therein is wholly unsustainable, and accordingly it is set aside. However, the state had been diligently agitating the grievance in a legal forum which it thought had jurisdiction. We grant liberty to the state assailing the order and a learned single judge in accordance with the law. Thereafter, my lords, after keeping this judgment in view, my lords, at page number 24, the Guwahati High Court, my lords, wherein this judgment was referred, and also the point raised by my friend stating that section 4 of our rules also doesn't state that. However, that has been answered here, my lords. Page number 25. This intra-court writ appeal arises from an order dated so-and-so passed by the learned single bench of this court in a criminal writ jurisdiction being criminal so-and-so. The said writ petition filed by the petitioner, appellant herein, appearing in person, seeking quashing of the FIR as well as the charges framed against him by the trial court, was dismissed by the learned single judge by the order dated so-and-so. On the previous date of hearing, we had instructed the registry to make a report regarding maintainability of the writ appeal. Office note dated so-and-so indicated that Rule 2, Clause 2 of Chapter 5A of Guwahati High Court rules are silent as to whether the intra-court appeal would lie against an order passed in criminal matter by Honorable Single Judge of this court under Article 226 of the Constitution of India. The Honorable Supreme Court in case of Ram Kishan Fauji was a state of Haryana and others reported in so-and-so had laid down that letters patent appeal does not lie against an order passed by the single judge of the High Court in exercise of criminal jurisdiction. In the said case, the writ petition filed the writ petition before the learned single judge of the High Court was filed under Article 226 of the Constitution of India, and the division bench entertained the letters patent appeal against the order of the learned single judge. The judgment of the division bench of Punjab and Haryana High Court was reversed by the 3 judges bench of the Honorable Supreme Court, laying down that the letters patent appeal, which is akin to the intra-court writ appeal, would not lie to the division bench against the order passed by the single bench of the High Court in exercise of criminal jurisdiction. Milords, the petitioner had relied for 3 judgments, milords. That was, and however, the paragraph 6, having regard to the discussion made herein above, we are of the firm view that the intra-court writ appeal does not lie against the order or judgment passed by the learned single bench in exercise of criminal writ jurisdiction under Article 226 of the Constitution of India. As the Guwahati High Court rules are silent on this issue, the anomaly shall forthwith be clarified with appropriate insertion in the rules clarifying the position that no intra-court appeal lies against an order or judgment passed by the learned single bench in exercise of criminal writ jurisdiction. As a result, the intra-court appeal preferred by the appellant herein against the judgment dated so and so passed by the learned single judge in writ petition so and so is hereby dismissed for as not being maintainable.
The other judgment
Of the this Honorable High Court, milords.
where is that?
That's
My lord,
That is-
the conclusions of this judgment, are not at its fag end. The conclusions of this judgment, Ramkrishna Poji, are at para number 46. So after
come.
para 46, the court is dealing with this particular case by making comparison of the class 10 of the Punjab and Haryana letters patent of the Punjab and Lahore High Court with those of the chartered high courts by class 15 of the chartered high courts, and then by comparison with the Delhi High Court, Gujarat High Court and Andhra High Court. While Andhra High Court had supported this contention that whether that in criminal jurisdiction also intra-court appeal will lie, the Supreme Court has concurred with the findings of the Delhi and Gujarat High Court. However, the general law has been enunciated in para 46, where it's clearly stated that an appeal shall lie from the judgment of a single judge to a division bench of the High Court if it is so permitted within the ambit and sweep of the letters patent. So in our letters patent, which are a substantial replica of the Article 136 of the Constitution, this, by use of this expression sentence, the adequate powers have been conferred to entertain an intra-court appeal even in criminal jurisdiction.
We'll come back. Any other judgment?
Judgment of this Honorable High Court, milords, that is in 2014-15, milords, that page number 53, wherein paragraph number 11,
Page
43. In view of the above discussion, we hold that the petition filed before the learned single judge, notwithstanding its nomenclature as one filed under Article 226 and 227 of the Constitution of India, read with section 482 CRPC, was actually one filed under section 482 CRPC. The learned single judge was justified in treating
This is on this fact. Otherwise, can't be a 482 petition because it is seeking relief beyond the territorial limits. That's the argument. Okay. Yes, ma'am. What do you say? Pardon? Where is that? What does it say? Which paragraph?
Paragraph, my lord, 10, my lord. Paragraph 16 in page 39 of the judgment, in page 39. We therefore hold that the courts at the place where the wife takes shelter after leaving or driven away from the matrimonial home on account of acts of cruelty committed by husband or his relative would depend on the factual situation, also have jurisdiction to entertain a complaint alleging commission of offense under 498 of the Penal Code. On this ground, my lord, the FIR which was registered in Panipat is And the intra-court appeal, my lord, cannot be maintained. The, my lord, my friend who was reading, my lord, the first judgment, my lord, this is where it says that, my lord, the conception of criminal jurisdiction as used in clause 10 of letters patent is not to be construed in narrow sense. It encompasses in its government inception of consequence. It is filled in respect of which jurisdiction is exercised, is relevant. Contention that solely because a writ petition is filed to quash an investigation, it would have a room for intra-court appeal. And if a petition is filed under inherent jurisdiction under 482 CRPC, there would be no space for intra-court appeal, would create an anomalous, unacceptable and inconceivable situation. My lord, this is what, my lord, if an intra-court appeal is entertained, my lord.
Which para you are reading?
My lord, my learned friend was relying on this judgment, 2017 judgment, my lord. The second page of the judgment. Ramkishan Fauji judgment, my lord. Clearly, my lord, it is why an intra-court appeal should not be entertained. It says, my lord, it would have room for inter-court appeal, and if a petition is filed under inherent jurisdiction.
Okay, we will reserve it on maintainability. Okay.
My lord, I have submitted a judgment of Kamalia judgment, where this Honorable High Court has entertained the writ appeal. That also I once again intend to bring to the notice of this.
Moreover, my lord, it's a matrimonial dispute. Serious allegations are also made.
My lord, page number 37. Page number 37.
Of your compilation?
Yeah, my lord, my compilation.
We are only reserving for maintainability. Okay?
Okay, madam.
Yes, we have heard.
Page number
37, we have noted. We will
page number 37, it is a writ appeal, my lord, which was preferred. The original complaint was filed in Bihar. And under Article 226(2), the single judge had transferred the investigation from there to here. Against that, this writ appeal was preferred. And this writ appeal was entertained and adjudicated also.
Okay. Just say that we have heard the appellants. You both are appellants?
Yeah, appellants.
Appellants in person, counsel for the state as well as respondent number 3. Is 36? No, 37. On the maintainability of the appeal. For the respondent number 1 and 2 and 3. You have for 3. Okay. Orders reserved. Thank you.
Date, my lord.
We'll give you, it will come in the list, Mr. Chadda. It will come in the list. Whenever we will pronounce it, we will give it in list. You have to just watch.
My lord, interim stay may kindly be granted, my lord.
When is the date now?
Sir, July, 22nd July.
Huh?
22nd July.
July, na?
Yes.
Yes. We have time. Okay. Thank you.
ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗೋದ್ರಲ್ಲಿ
ಇಲ್ಲೇ ಬರುತ್ತೆ.